Greetings from Tokyo. I'm Miyasu Miyazaki, attorney at the Minister's Secretariat International Affairs Division of the Ministry of Justice of Japan. I will be acting as program moderator today, and it is my great pleasure to welcome you to the 2024 Tokyo Forum on Dispute Resolution. Without further delay, we will move on to opening remarks. Unfortunately, the Assistant Vice Minister of Justice, Ms. Noriko Shibata, is unable to be here due to her official duty. So, the first opening remarks will be delivered by Director of the International Affairs Division of the Ministry of Justice, Mr. Takeshi Matsumoto. Mr. Matsumoto oversees basic policy planning and coordination of all matters concerning international affairs in the Ministry of Justice. Mr. Matsumoto, you have the floor.
Good morning, everyone. My greetings to distinguished participants here with us and joining online from around the world. I am Takeshi Matsumoto, Director of the International Affairs Division of the Minister's Secretariat of the Ministry of Justice of Japan. It is my great pleasure to convey my remarks at this opening of this forum on behalf of Ms. Noriko Shibata, Assistant Vice Minister of Justice. The Ministry of Justice of Japan is very pleased to be able to co-organize with UNCITRAL and ICSID once again this gathering 2024 Tokyo Forum on Dispute Resolution to discuss the various key issues in the field of international dispute resolution. We are delighted to have here Ms. Anna Giovambre, the Secretary of UNCITRAL, here in Tokyo, and Ms. Meg Kinnear, the Secretary General of ICSID online. We are also excited to have distinguished speakers and participants joining us in person or online from around the world. Dispute resolution is a cornerstone for the delivery of justice and the promotion of the rule of law. Japan is dedicated to promoting the rule of law internationally, and the Ministry of Justice of Japan plays an important role in ensuring that the rule of law is achieved through fair, just, effective, and efficient dispute resolution proceedings. Notably, the ASEAN-Japan Special Meeting of Justice Ministers was held in July 2023, where we collectively showed our commitment to strengthening our cooperation in promoting rules-based resolution of disputes arising from cross-border business transactions through the use of alternative dispute resolution mechanisms, including by using digital means. As part of our endeavor to promote the rule of law in the ASEAN region and beyond, we are honored to co-organize this forum with two key intergovernmental organizations in the field of dispute resolution, namely UNCITRAL and ICSID. As for UNCITRAL, as you may be aware, Japan has a particular interest in the project on the stocktaking of developments in dispute resolution in the digital economy, or in short, DRD project. This project was proposed by Japan at the Commission's session in September 2020 and approved by the UN General Assembly in December 2021. We are very pleased to see that the project has been steadily making progress under the leadership of Ms. Anna Giovambre. At the Commission's 56th session last year, I was pleased to hear and feel the enthusiasm for and the strong interest in the DRD project expressed including by ASEAN and other developing countries. We are very much looking forward to the notes by the Secretariat to be presented at the upcoming Commission session in July. This forum will be an important opportunity to sum up the discussions until now and discuss further what is expected of the DRD project from governments, practitioners, academics, and businesses based on the progress made to date. We are really excited to realize we are getting closer to the next stage, and I hope that the Commission will mandate a working group to discuss further issues based on the findings and work proposals originating from the stock-taking project. Regarding the ICSID, Japan is one of the first contracting states to the ICSID Convention. There is a long-standing relation between ICSID and Japan, and we have further strengthened our ties in various ways, most importantly, through the successful discussions which took place in this forum in previous years. Japan participated closely and actively in the Rules Amendment Project, and having contributed to the amendment process. This achievement was special also for the Ministry of Justice of Japan. We welcome the new rules which reflect principles and the key elements of dispute resolution. In Session 1, featuring ICSID, as a follow-up to the discussion, which took place at the last forum, we will be hearing how practice under the new rules has further developed in ICSID. We will also be hearing about other important issues, such as those in relation to the UNCITRAL Code of Conduct for Arbitrators in international investment dispute resolution, which is a product developed and adopted last July as a result of collaboration between the secretariats of UNCITRAL and ICSID. We are very much looking forward to the discussion today on how the development of new norms and rules have had an impact on the realm of international investment dispute resolution with prominent professionals and academics. In conclusions, I wish to extend my sincere wishes for fruitful discussions to all speakers and participants, and let me say a final word in Japanese. 東京フォーラムへようこそ。Welcome to the Tokyo Forum. Thank you very much.
Thank you, Mr. Matsumoto. Next, we have Ms. Anna Jobambre, the Secretary of UNCITRAL. It is an honor to have Ms. Jobambre here with us in Tokyo today. Ms. Jobambre is the 9th Secretary of UNCITRAL since its establishment by the United Nations General Assembly in 1966. Ms. Jobambre, you have the floor.
Ladies and gentlemen, distinguished participants, it's a great pleasure and an absolute honor to be here today for this third edition of the Tokyo Forum, jointly organized with the Ministry of Justice and with our friends and colleagues from ICSID. We are delighted to be here in this hybrid mode, which allows us to bring in an inclusive manner, participants from abroad, and to also benefit from the wisdom and the interventions from colleagues and friends from other regions. I'm particularly grateful, and I would like to say that at the outset, for this Hanami touch. I was dreaming of coming to Tokyo for the cherry blossoms. It's a bit early still, but I'm particularly touched by seeing this bouquet, which is a wonderful background for our interventions from the podium. So thank you wholeheartedly. Let me give you a very brief overview, because we're going to be delving into it in detail in the course of the day. Let me give you a short overview of what UNCITRAL has been working on in the last year, since we met last year, and particularly with the view of enhancing credibility, certainty, and enforceability, as the title of our forum is. In the area of dispute resolution, I would say in the area of traditional dispute resolution, arbitration and mediation, quite a lot has been done on two different areas. One is to finalize a set of rules and of model clauses for technology disputes and adjudication. And in that context, we are going to bring the final clauses for adoption by the Commission in July in New York. And we have also made a lot of progress, and you will hear more about that, on one of our key programs in the area of dispute resolution, namely the dispute resolution in the digital economy, the stock taking. And here we will bring today, during this conference, we will bring the findings and a number of areas that have been explored and on which we have begun to crystallize some possible advances and possible future work. So we're looking very much forward to this end of an exploratory phase and moving it into the development phase at the Commission session. On Working Group 3, we've also made quite a lot of progress. It's a project that we've been working on for a long time, going through 3 different stages of development. A first one, which was very important, which was, again, a stock-taking phase, during which we were able to listen and to better understand the concerns, the difficulties, the problems faced with investor-state dispute settlement from all parties, all actors, in a very broad and open and transparent manner. And at the same time, we also started receiving proposals from states on what they wanted to achieve with this reform process. And through these proposals, through the main concerns that were summarized in coherence, in cost and duration, and in legitimacy issues, we then started developing and unrolling the different reform elements. And we're now in the production phase, which means that every year, hopefully, I'm crossing fingers, we will be bringing to the Tokyo Forum the latest developments in reform of investor-state dispute settlement. We had the pleasure of working with our colleagues from ICSID on a code of conduct, which was the first fruit that we harvested collectively. We also worked on enhancing mediation, and we had the opportunity of discussing it yesterday, of enhancing mediation in investor-state dispute settlement, because it's a credible and effective means of settling investment disputes. And we are now bringing to the Commission this year 2 major building blocks. One is an advisory center for developing countries and least developed countries to assist them in these investor-state disputes, really with a view of rebalancing or re-leveling the playing field and making sure that this perception, maybe more perception than a reality, that states are at a losing end in investor-state dispute settlement can be corrected, and that states that don't have deep pockets and don't have sufficient, I would say, human and financial resources are not at a disadvantage. So this advisory center will be presented for adoption, and hopefully its launching will also start fairly soon. And at the same time also work on the dispute prevention policies, which are equally important. It seems obvious, but it's like for the firefighters. You only hear about the fires when the house has been burning down. You don't hear about the number of interventions of firefighters that have resulted in a successful conclusion. So we hope to bring this to the Commission this year. And of course, we are extremely grateful for all the support we're receiving from our member states, but from Japan in particular. Japan is a very committed state in UNCITRAL, very supportive, interested in the work we do in many areas, and particularly in the area of dispute resolution. We have the pleasure of being surrounded here by participants in our working groups 2 and 3. So I look very much forward to this discussion today on your turf in your place with the players and actors of dispute resolution here in Japan to further enrich our understanding and build bridges between all of us. So thank you very much for this opportunity, and welcome to this third Tokyo Forum on Dispute Resolution. Thank you very much.
Thank you, Ms. Jovambre. We are also honored to have Ms. Meg Kinnear, the Secretary General of ICSID, with us online. Ms. Kinnear was first appointed as Secretary General in 2009, and she's in her third term as head of the institution which administers more than 300 investment arbitration cases each year. Ms. Meg Kinnear, you have the floor.
We are also delighted to be able to participate in this third edition of the forum. And I'm sorry I am not there in person, but I am glad I can participate at least remotely. And my colleague Jerry will be helping us out today, both with the PowerPoint in the first section, and she will also take on moderating duties for the second panel. So we hope that you will enjoy this. As Anna has told you, we are in a period of reform of investor state, and it is an interesting period. It is a new discipline that has evolved a lot in the past 60 years, but it is one I think that remains in many respects a mystery other than to those who are actually involved in the day-to-day practice of investor state. And it is one that in many ways has attracted a lot of media attention and a lot of discussion. Some of it, to me, frustratingly inaccurate, but some of it obviously very accurate. And I think one of our strengths is that we are able to look at the things that do need reform, and we've made some very concrete efforts in the last several years that Anna in particular, and ICSID in its own way, have been very much in the vanguard of. For ICSID, our major project, of course, was the amendment of the ICSID rules. And that passed in and became effective in July of 2023. So we now have roughly just a little bit over 1 year practice, and we're able to report back to you on what we have seen and how these are working. We recognize that it's not enough to just pass the rules. What really is going to matter is that we track them and we make sure that they are achieving the ends they were meant to achieve. And among those were obviously to improve on time and cost of arbitration, to make mediation and other ADR techniques more available, and to address some of the ethical issues that have been raised in the discussion on investor state. Well, our job is, first and foremost, to administer cases, and as you noted, we have roughly 300 ongoing at this point, so that is obviously a very busy job. We also try to contribute to the discipline of investor state. And so, for example, today we released a paper on annulment, which I think if anyone is involved in an annulment or interested in that, they will find this a very useful paper and a very practical paper, which brings you up to date on the jurisprudence and sets out the very granular practice followed in the annulment process. In the next several weeks, we will be issuing a paper on enforcement of awards, and that's something that is also the topic of a lot of discussion. It is certainly one of the strengths of the ICSID system with its simplified enforcement mechanism, and I think the statistics that we'll be bringing forward will be of great interest to those who follow this area. Now, without any further ado, I'd like to start our session on the Code of Conduct for Arbitrators. And this is something where we will be joined at the end with Anna, who we were partners with throughout this process. But as well, we have, and I hope you can see on the screen, colleagues Abby Cohen-Smutney, Michael Nolan, and Dr. Chiara Giorgetti. And they will all be talking to a particular aspect of the code. I would like to start our discussion by having a short overview of the code. I don't know how many of you have read it, but I'd obviously highly recommend. It is a short document, but what is extremely useful is that it is accompanied by a commentary, which explains a lot of the questions that delegates raised during the discussions and really enlightens us on exactly what the words of this code mean. So I wanted to just bring that to your attention. Jerry, I think you will be doing the PowerPoint, and I must say, I can't see the PowerPoint here, so we're going to have a very masterful job of trying to coordinate while we go ahead. But let me start with a little note on the history of this code of conduct. Interestingly, this was one of the topics that our member states were very keen on addressing during the ICSID amendment. And at the same time, UNCITRAL was thinking about addressing a code. So it seemed logical for us to join forces and to try and create one code that could provide uniformity and address all of the points that were being raised by delegates, but also by civil society and by those in practice. We began this work basically in 2020. And between 2020 and 2022, there were actually 5 versions of the code, everyone more elaborated. And in between these drafts, we met and had very good discussions on how the code was drafted and what it meant. And we also received a number of written comments. So that really helped to make this much more precise and much more relevant to the concerns that people had. Anna was talking about harvesting fruit. And I have to say, I'm not sure why we're keen on fruit metaphors, but the biggest metaphor that was around when we did the code of conduct was that this was low-hanging fruit. In other words, everyone felt that this would be a fairly easy to agree upon first reform, and it would get us off and get us some momentum to go on to some of the other more difficult topics that are now before Working Group 3. As it turned out, that fruit was not as low-hanging as everyone expected, and it took us a little bit of time to get to full consensus on the document. Ultimately, however, it was adopted at the UNCITRAL Commission on July 8th of 2023. So we were successful, and now we're in a period where we are trying to make sure that people know and understand the code, and hopefully we will start seeing it applied in practice. I'd like to quickly just take you through some of the main provisions so you get a sense of its structure and its contents. So the first key is obviously Article 1, which contains definitions. Key parts are that this code applies to international investment disputes, and that's essentially a cross-border dispute between an investor and a state or a regional economic integration organization, something like the EU. It is what is used as an instrument of consent to arbitration. That's where you get the agreement for the parties to go to arbitration to get their dispute resolved. We find this in about 75% of the cases is based on an investment treaty, but we also find investor-state dispute settlement coming out of contracts and in some cases foreign investment law. The other key definition are the ones, not surprisingly, about arbitrators. And of course, this code has to differentiate between candidates, and a candidate is someone who has been contacted by a party or by an institution to ask them if they would consider being nominated, but they have not yet been appointed. So it's in the very early phases. Interestingly, a lot of the obligations here actually come up and are applied in the early phases, including in particular the disclosure. So the time of being a candidate is actually a very important one for meeting your ethical obligations.
Meg.
The second key is an arbitrator, and that, of course, is somebody who has accepted that request to act in a case. And it applies both to arbitrators in panels, often in 3-person panels, but it also applies to ad hoc committee members in ICSID. The code applies according to Article 2. to these kinds of disputes. And I think the interesting part of Article 2 I'd like to draw your attention to is that there is a formula to decide what applies where you have the situation of an actual instrument of consent, let's say a treaty,
Meg?
that has its own specific.
Meg?
Yes.
Hi, I'm sorry. We're having some technical issues, so we still need to
Okay.
get the PowerPoint up.
All right, Jerry, you keep going on that so we don't lose time.
Okay.
I'll keep speaking, but you can catch up with me with the slides. That would be tremendous.
Great.
So in Article 2, basically, it talks about the situation where for example, treaty might have its own code, and then this code might be applicable. And how will we decide what is applicable? And essentially, the two codes are meant to be complementary, but where they absolutely could not be applied together, and there is an incompatibility, then it is the consent document and its code that will govern. This is going to be something interesting in practice because this, of course, will happen essentially at the beginning of the case when a candidate has to say, what is it that I need to disclose? And we'll have to decide if there is some kind of a difference between them, what is the obligation that they must meet? And I think we will see that this perhaps could fuel some challenges, and it will certainly call upon arbitrators to have to say to themselves, what is the standard here? And I suspect many will say out of caution, I will meet both the standard in the treaty instrument as well as that in our code of conduct. And I see now we have our slides up to date, and Jerry will bring you to Article 3, which we're going to go to next. And that's, of course, the foundational article in any code of conduct, and that is the obligation that the arbitrator be independent and impartial. That, of course, is found in the ICSID case law and in the ICSID convention. What's interesting about this code is that it requires not only that arbitrators be independent and impartial, but it also includes in paragraph 2 a list of specific situations that the arbitrator must meet and that they must address in their declaration. Some of these you can see as examples of independence and impartiality. Some you might think are a bit different than independence and impartiality, but they certainly all must be met. So the arbitrators must think about their independence and impartiality, plus this list of 6 specific items, including things like not being influenced by loyalty to a party, not taking instructions, for example, by an outside party. And it ends in the 6th subheading F with not taking any actions that could create the appearance of a lack of independence or impartiality. So you'll see that this code sets a very high standard or high bar. The next section is Article 4, and that was probably the most difficult article for us to look at. And Abby will be addressing that in a few moments. So I just want to draw your attention to the topic. And this basically deals with what people call double hatting, although here it's called addressing multiple rules. And it talks essentially about not having a situation where the same person is the legal representative of a party or an expert witness in a case that deals with the same situation they're dealing with as an arbitrator. The idea that they so-called wear 2 hats at once, and the concern that that creates either a real partiality, or more often the concern is that it creates some kind of an appearance of partiality. And of course, neither of those are healthy for the system. The trick here was trying to decide what circumstances should be prohibited from double hatting. And that was hard for parties to define. There's really no case law definition to date. There's been a lot of discussion, but parties are not ad idem on that. So I think probably for the first time you see here that the code came up with 3 particular situations where they said this cannot happen because it is impermissible double hatting. And the 3 situations were where you had the same measures, in other words, an arbitrator dealing with the same measure as an arbitrator, or as a council at the same time. And I'd say that's something that certainly we don't see, because that's something as an institution, for example, that we would have said to the arbitrator, you can't do that. That's not appropriate in the rules. The second situation was where there were the same or related parties in the two cases. And the third was where you had the same provisions of the same instrument of consent. So think, for example, of somebody dealing as a council with expropriation under the Energy Charter Treaty, and at the same time being an arbitrator in a case dealing with that obligation under the Energy Charter Treaty. And all of these have both a prohibition, and it lasts for a cooling off period after the case has ended. In the case of measures or parties, a 3-year cooling off period, and in the case of the same provisions, it's a 1-year cooling off period. Now, I think something should be noted here, which is this is a prohibition on double hatting. There are still some circumstances where one might think there is something approaching double hatting and wouldn't fall under this particular section, but I think in all circumstances, it would, if it's a realistic concern, fall under Article 3, independence and impartiality. So in that way, the two concepts are linked. In Article 5, there is a requirement of diligence, and you will see that it essentially requires the arbitrator to act diligently, and it focuses on timeliness, which is a very key provision right now. And I think this will certainly complement the new ICSID rules, which have shortened some time periods, have specifically listed some time periods, and that is something that we've tried to address very carefully. So it's certainly complemented by this duty of diligence. Article 6 is what you might call the third duty under this code of conduct, and that is the duty of integrity and competence. And you will see the key issue there, and the one that has had a lot of public discussion, is what people call the fourth arbitrator problem or issue. And essentially that relates to a situation where it's felt that an arbitrator has an assistant, and that the assistant in many ways is exercising the powers of the arbitrator. And the allegation that's made is that the assistant indeed perhaps writes the award. Again, I think most, if not all, arbitrators recognize that that's not appropriate, because what's important is the arbitrator's discretion and knowledge. So there's a very important line between the role of an assistant, and they can be extremely helpful, both in terms of keeping the time down and making things more efficient, but not having them go into that role of actually making decisions. On Article 7, it deals with ex parte communications, and the basic rule is quite a simple one. Unless it's expressly allowed, ex parte communication is not allowed under these rules. And there's one main exception which reflects something very specific, I think, to arbitration, and that is that a candidate is able to have a pre-appointment interview with the parties. This is a device that is used in some jurisdictions. Some lawyers don't do this, but many arbitration counsel find this is very important. And so they will speak to an arbitrator they are thinking about appointing. And the key is they may not speak to them obviously about the merits of the case or the substance of the case. What they're really focusing on is things like the experience, the expertise of the arbitrator, the availability of the arbitrator, and ensuring that there is no conflict of interest. In Article 8, it speaks again about confidentiality. And again, the broad principle you can distill from this is that an arbitrator cannot disclose information that they obtain by virtue of their participation in the case, and in particular, cannot disclose the draft decision. And that's kind of interesting, because we've had a few arbitrators actually adopting a method whereby they intentionally get the consent of the parties, and they get a draft decision. In other words, it's ready to be released, but as a final step, They share it with the parties to get any last-minute comments, to catch any obvious errors if there are any. So it's not meant to be an opportunity to re-argue, but it is meant to be yet another tool that hones the award and makes it less prone to review or annulment. We've seen that in a few situations, and it'll be interesting to see if it's adopted more broadly. If you do that, obviously, and this code applies, you will have to have the parties both specifically agree that you will have this draft decision technique in advance. Arbitrators, of course, may not disclose deliberations, so while there may be differences of views that are worked out between the arbitrators before the award is issued, those must forever remain secret. The other point here is that arbitrators cannot comment on a decision until it is final. And there's two key points here. Number one is that the decision must be made public and be final according to the applicable rules. And we know in some circumstances, investment cases are leaked, and that is not being made public according to the applicable rules. So that would not be something that the arbitrator could comment on under this code provision. The other point here is that the arbitrator must wait until the proceeding is final. And that doesn't just mean the end of the tribunal stage, but for example, the end of an annulment stage, if there is an annulment, or at the very least, the expiry of the time to file an annulment. So that is how confidentiality is addressed. There is a next section, Article 9, on fees, and essentially fees must be reasonable, and arbitrators have to keep accurate records of those fees. Under Article 10, we come back to the question of assistance. And here it establishes essentially the need for the parties and the tribunal to agree on the role and scope and duties of an assistant in advance of taking on that assistant. And ideally, where that agreement is made, it should be included in a first procedural order so parties can go back to that if they're ever concerned about whether the assistant is doing the work that all agreed that they could do. Now, the assistant is working with the arbitrators, and so if there's any concern about not meeting the code requirements, it is the arbitrator who must address that because ultimately they're responsible for meeting the requirements of the code. Number 11, and Jerry, I think we have to flip two slides here, thank you, is disclosure, and disclosure is key for this code of conduct. Basically, the intent was to have extremely broad disclosure. And you might, when you read it through, feel that, in fact, there is disclosure of facts that perhaps go beyond things that show impartiality or independence. But the idea is that both parties have a lot of information and a lot of knowledge. So the disclosure obligations are very clearly and quite comprehensively set out in Article 11. And of course, the arbitrator must make this disclosure at the very beginning of the case and has a duty throughout the case to keep that up to date if a new issue comes up. Sometimes an arbitrator has a difficult problem disclosing because they have to disclose things that are confidential in another case. They might have to say, I'm involved in another case, there's some kind of a relationship, but that other case and their participation in it is confidential. What is done and what is expected under these sets of rules is that the arbitrator will disclose to the extent possible, and hopefully that satisfies the parties. If it does not, or if the arbitrator cannot disclose because of confidentiality, they would not be able to take on the mandate in that case. Mike is going to talk a little bit about the disclosure issues. And then finally, to get you through the code, Article 12 talks about compliance. And as at the end of the day, the methods that this code adopted for compliance are recusal, the idea that an arbitrator would step down from a case because of a concern about impartiality or failure to meet one of the duties under the code, or the mechanism of challenge, where one or the other party actually brings a formal challenge to the arbitrator continuing to sit in the case. During our discussions at UNCITRAL, there was a very interesting and a fairly lengthy discussion about other options. Challenge and recusal, I think, are the traditional ways that we've dealt with ethical concerns in the arbitration context. And there was a discussion about whether other mechanisms might be proposed and might be useful in the context. And Kara is going to talk to us about that as we move forward. The final thing I wanted to note for you is that right now the code is considered a soft law instrument. It is certainly available for parties to adopt in a specific case by their consent, and it is an instrument that states may want to embed into their new investment treaties. So that is a little bit of a run, frankly, through the Code of Conduct, but to give you a little bit of familiarity with how this has been put together and what it covers. I'd like to go now to Abby, who's going to talk to us in particular about Article 4 and double hatting, which, as I say, was probably the most difficult part to reach consensus on. So Abby, over to you.
Well, thank you. And of course, it's my pleasure to be able to address you today, albeit remotely, and I appreciate being given the opportunity to do so. So thank you. I'm going to speak about Article 4 of the Code, which is referred to as limits on multiple roles. As Meg explained, this article is aimed at what is frequently called double hatting, which is the situation in which one individual may be serving as a counsel in one case, a legal representative, or an expert witness, and at the same time is serving as an arbitrator in another case. This is the notion of double hatting. The nature of the issues that come up in investment arbitration frequently repeat. Very similar concepts are addressed over and over again in investor-state arbitration. And so the concern, which has been articulated in many contexts, is that if one is deciding an issue as an arbitrator in one case, it presents a conflict of interest or an appearance of a conflict of interest if at the same time that same person may be benefiting by serving as counsel on that issue or somehow helping a client by deciding an issue in a certain way. So the idea of avoiding this type of conflict of interest or appearance of conflict of interest really relates to preserving the integrity of the arbitration process and, really equally important, avoiding the appearance of conflicts to ensure trust in the system. This is really an important point. So the Code's basic limitation in Article 4 states that an arbitrator, and I'm going to paraphrase a little bit, that an arbitrator must not act concurrently at the same time, must not act concurrently as a legal representative or an expert witness in any other proceeding involving either the same measure, the same parties, or the same provision, the same, let's say, provision in a treaty. So the idea is to not act at the same time in the same proceeding regarding, let's first talk about same measure. What does that mean? Well, it can mean when a state takes some action that perhaps places a limitation on some group of investors, and perhaps multiple of these investors choose to bring in arbitration, really complaining about the same thing, but these may be separate arbitrations. So that's an example of what we mean by same measure, when a state does something that perhaps impacts multiple investors. That's one example. So the next is the related parties or the same party. So we're talking about a parent and a subsidiary of some corporate group, or you could consider the same party the state, because sometimes a party is acting as a counsel representing a state should not at the same time be sitting as an arbitrator in another case involving that state. So same parties could be on the investor side or on the state side. Then we have the idea of same provision in the instrument of consent. The most frequent example is the same treaty provision. And here we mean same. Same means same. So what this refers to is an example of, let's say, Article 10 of Treaty A. If that same article is addressed in one case where a party is sitting as an arbitrator, that same person should not be counsel in a case regarding that very same treaty provision. The code also states that a former arbitrator, so someone who has completed his or her job as an arbitrator, must not act for a period of 3 years. This is that cooling off period that Meg referred to. Must not act for 3 years as a legal representative or expert witness involving the same measure or the same parties. And that cooling off period is only 1 year when we're referring to the same provision of that instrument of consent, that same treaty provision. So different cooling off period. This really, it seems like a very narrow restriction, 1 year or 3 years, because it's referring to pretty narrow types of sameness. But one thing to emphasize here is that these time limitations run from the point in time in which the arbitration is completed. And the reality is in that the vast majority of investor state cases do go on for 3, 4, or more years. So the limitation temporally is longer than first meets the eye. But nevertheless, I would emphasize how narrow the sameness is in each of the categories. So just for an example of the same provision of the same instrument of consent, the same treaty provision. So that, just to clarify, let's say Article 10 of Treaty A, same treaty, that's where double hatting is prohibited. It does not mean any treaty provision that may be similar, for example, regarding the extension of fair and equitable treatment, a very, very common provision. So again, how narrow the subject matter is, I think, is something to bear in mind. That subject limitation, that a person cannot act as an arbitrator and then as a counsel, how narrow that is, let me emphasize, not similar. The vast majority of, I think, concerns where we're talking about double hatting really do relate. And I think this is probably why it was so actually surprisingly contentious to consider what could be agreed, is if you have an arbitrator sitting in one case deciding what does expropriation mean in a certain fact pattern, or what does fair and equitable mean in a certain fact pattern, and at that same time that person is arguing a similar fact pattern, again, about expropriation or fair and equitable treatment, very common provisions, that type of double hatting is not covered by the code. So bearing that in mind, and also bear in mind that so many of the investment treaties have practically identical provisions. So I would emphasize in that respect the narrowness of the limitation. One final point to mention about the scope of these limitations is that they are all subject to the provision that the parties are free to agree otherwise. So parties are free to waive this restriction, to accept a double hatting in a certain circumstance. But I have to say, it's interesting that it's stated, and I think it's natural that one would say that parties have freedom of choice. I think in a circumstance in which the issue arises, how often would a counterparty actually agree? I think probably that would be a very rare case. But nevertheless, recognizing freedom of contract, I think I would be a little concerned about any party feeling coerced in this context. But in any event, parties are given freedom to agree. So some ask whether these provisions, these limitations, double hatting, are these limitations desirable for the investor state investment arbitration system? Do they have some negative effects? Is limiting double hatting a problem somehow? Does it narrow the pool of arbitrators? Does it create undue barriers to entry, particularly for lawyers in underrepresented groups? These are concerns that one hears raised, and I think fair questions to ask. My own sense is that the rather modest limitations on double hatting that are actually set forth in this code those limitations are addressing the most direct types of conflicts. So in my view, it's not a terribly significant limitation on double hatting. There does remain ample opportunity for those who serve as counsel in investment arbitration to accept some appointments also as arbitrator in some cases. And so I think that was that low-hanging fruit, perhaps, concept. The most direct conflicts are really the only ones that are limited by the code. So again, while one may debate whether a strict limitation on all double hatting would unduly restrict the system, and I think that's fair to debate, that's not what the code does. The code does a very limited restriction. I would end my comments here by emphasizing how important trust in the system is, how important it is to avoid the appearance of conflict and bias. It is not enough for practitioners or arbitrators to persuade themselves that they would approach the role of arbitrator independently and impartially. As we know many do, no doubt, we all persuade ourselves of our own good intentions, but these issues must be viewed from the point of view of the skeptical parties who have a serious dispute before them and other stakeholder observers with keen interest in the issues that are being decided. And when they don't consider the process to be fair, when they think it's too clubby, it seems too biased, the system loses its effectiveness. So this small step reflected in the code, in my view, is a useful step on a very important aspect of having an effective system of dispute resolution. So let me end there and turn it over to the next topic.
Thank you. Mike, you were going to talk to us a little bit about declarations, which are a key implementer of this code.
I was muted, so you were spared. My task is to address Article 11, which is disclosure obligations. And my hope is that I will be able to give you a little bit of a sense of the structure of that article and then flag some of the issues that we will all be contending with as it comes into play. I'm going to try to share my screen because I want to call your attention really just to some of the language of the article. So this is not a very elaborate PowerPoint presentation. It's just a mechanism really to focus you all on some of the actual language of Article 11, and there may be one or two other things I'll call your attention to as well. What I want to begin with is the beginning of Article 11, the first two paragraphs. Article 11 contains two disclosure obligations. The first disclosure obligation is that a candidate and an arbitrator shall disclose any circumstances likely to give rise to justifiable doubts as to his or her independence or impartiality. Now, with respect to this first obligation, I want to direct your attention to the fact that there is a standard articulated within it, justifiable doubts. That is the standard triggering the disclosure obligation. I want to talk to you about that and what it is that must be disclosed under this first paragraph are justifiable doubts as to independence or impartiality. Independence or impartiality. And we'll talk about what is the substance of that as well. Then there is a second disclosure obligation, regardless of, let's see, can you please share your screen? I thought I just had a question. Is my screen being shared? I thought it was. Can people see it?
Yes, you may just
Okay, good. So
PowerPoint.
assuming that that was successful, I'll continue. So the second disclosure obligation is a mandatory disclosure obligation, regardless of whether required under paragraph 1, the following information shall be disclosed. And the list goes on from what's on this first slide, and we'll talk about it. But the point here is that there is something very specific in addition to the first disclosure obligation. With respect to the first disclosure obligation, I think a question is, does it really represent a change of practice? These same words really appear in the UNCITRAL arbitration rules, for example, and will be very familiar to people who practice in this area. Now, that doesn't mean that it's easy to know what's required, but this kind of formulation and approach may not really be much of a change on its face from what many of us expect and see. What I want to focus on, though, first is the standard justifiable doubts. And if one looks at the commentary, which is always important with respect to materials like this, UNCITRAL materials in particular, paragraph 76 refers to the standard in paragraph 1 as being broad and covering any circumstances likely to give rise to justifiable doubts as to independence or impartiality. Doubts are justified, and here is something that's key, if a reasonable person having knowledge of the relevant facts and circumstances would reach the conclusion, and then it continues, that there's an absence of independence or impartiality. So it's a reasonable person, or what we refer to as an objective standard, at least by reference to this paragraph of the commentary. Justifiable doubt, reasonable person, objective. I think what's interesting with respect to this standard is that the plot thickens a little bit if you read further in the commentary to paragraph 76. And it refers to circumstances likely to give rise to justifiable doubts. And then there's a reference to existing international standards, such as the 2014 IBA guidelines, which may provide useful practical guidance as to the types of circumstances that require disclosure under paragraph 1. Now, what I think is of interest is if one then looks at the IBA guidelines, they refer to conflicts of interest in reference to a reasonable third person having knowledge of the facts, an objective standard. And then they proceed to disclosure by the arbitrator. And with respect to disclosure, the IBA guidelines are thought to convey a subjective standard. If facts or circumstances exist that may, in the eyes of the parties, give rise to doubts. So there's the introduction under this approach of a subjective element. And if one looks at the text of Article 11, there's a reference to justifiable doubts, but the commentary contains reference both to justifiable doubts and what appears in the eyes of the parties, or a subjective standard. And having flagged that matter, I'm not going to have much more to say about it right now. I'm just going to proceed to the mandatory disclosure obligation, which is the second paragraph of Article 11. The mandatory disclosure obligation is interesting because it contains specific reference to specific matters that must be disclosed. I didn't include those on the slide, but let me, since we're sharing the screen, call up Article 11 itself. And you can see that the first subparagraph is any financial, business, professional, or close personal relationship. And then there's some delineation of that. It's essentially relationships. And if you look at the other subparagraphs, I think, and I commend you to do this yourself, I don't want to take you through all of them given the limited time, but the real focus of this second mandatory disclosure obligation is essentially relationships. Relationships are what we typically think of when we think about independence in this context. The commentary uses the words effective control. So there's a concern about relationships that convey some lack of freedom by virtue, for example, of financial, business, professional, or close personal relationship. And I want to just commend to your attention that the thrust of this mandatory disclosure provision is really not the subject matter that Abby was referring to, in part with respect to double hatting, which are issues that go to partiality or bias that one might acquire, for example, by occupying multiple roles. That's what we frequently think about when we talk about impartiality. Now, obviously, there's a relationship between independence and impartiality, and those things that put one under effective control or create financial interest can affect one's state of mind, and therefore their partiality or bias. But these are distinct concepts, and I commend to your attention that really the focus of the mandatory disclosure obligation are relationships. And without going at any length into a war story, because it wouldn't be a very interesting one if I did, recently in a case, there was some discussion of these new standards. And the discussion focused upon relationships between a member of the tribunal and adversary counsel that arose when they were doing counsel work together. And a question arose whether adversarial relationship between lawyers qualify as a professional relationship that would require disclosure. And that then led to the question of if the professional relationship is with a legal representative, is the legal representative the individual lawyer functioning in a case or the law firm of which that lawyer might be a member? And therefore, what is the nature of the professional relationship that requires disclosure? This is another matter that I'm simply going to flag for you, but this reflects a discussion that came up recently. Now, there's a lot in the commentary that I think is of interest with respect to all of this subject matter, but because close personal relationships are something that we all have, and sometimes it's hard to know exactly what they are or what qualifies as a close personal relationship, I wanted to call your attention in particular to paragraph 83 of the commentary, which talks about what close personal relationships include, a degree of intimacy, which is beyond that of financial, business, or professional relationship. However, being in the same class in school, casual or social acquaintances, or distant family ties would not necessarily establish a close personal relationship, not necessarily establish that. So I guess in some circumstances it might. But I want to call your attention in particular to this paragraph 83 and the sort of personal relationships that require disclosure. Now, those are the two broad obligations that exist under Article 11, the first and second paragraph. The rest of the article is interesting in talking about how it is that a candidate or an arbitrator should discharge the obligations contained in those first two paragraphs. And I want to call your attention to paragraphs 4 and 5, which refer to the fact that a candidate or arbitrator shall make all reasonable efforts to become aware of such circumstances and information. And the paragraph 5 refers to the necessity that a candidate or arbitrator disclose or err in favor of disclosure rather than non-disclosure. So this triggers back to what Meg was talking about, is the broad obligation to disclose under this article. And there is an affirmative obligation that is put upon the candidate or the arbitrator to discover and figure out those relationships. It's not something under the article that's merely a passive obligation, but one that has an affirmative quality. And the disclosure itself must err in favor of affirmative disclosure instead of the other way around. Also important is the issue of confidentiality in arbitration. There are frequently instances where professional or contractual obligations exist that make it difficult for disclosure to occur. And this is a partial quotation from the commentary. A candidate or an arbitrator must therefore err in favor of disclosure and ensure that the disclosure includes circumstances or information that may, in the eyes of the disputing party, give rise to doubts as to his or her independence or impartiality. Now, in the event that confidentiality prohibits such a disclosure from being made, the candidate in that instance, if they're not able to disclose circumstances that may give rise to justifiable doubts, has an obligation to decline the appointment. So there is a resolution of the issue of confidentiality when disclosure is not possible, but the article also contemplates that to the extent that disclosure is impeded by a confidentiality obligation, the arbitrator or candidate may make disclosure to the extent possible given the confidentiality obligation. So that's essentially how confidentiality is dealt with in Article 11. It's interesting that if there cannot be disclosure due to confidentiality, there is an obligation not to accept an appointment. In the event, however, that there is not disclosure of a matter, the article is expressed that there shouldn't be a presumption of a conflict as a result of that non-disclosure. And I think this is useful to flag, and that there's a certain kind of recognition of humanity contained in the article, in a recognition that there may be circumstances where a disclosure isn't made simply because it's difficult always to make those disclosures, notwithstanding the affirmative obligation to do so. And in those instances, the mere fact of non-disclosure is not dictating an outcome or a necessity for withdrawal or non-acceptance. So I commend you to look and give more attention than I've had time to do at the article, but in particular, I direct your attention to the commentary, which is really interesting and really meaty, and there's really quite a bit in there. And you can see plainly as you read it, there is some resolution of disputes, sometimes perhaps not completely clear what that resolution is, but by reading the commentary, it'll give you a much richer understanding of what Article 11 entails and requires.
Thanks very, very much, Mike. That helps drill down a little bit into the wording, so that's really helpful. We're going to close up with Chiara, who's going to talk to us about remedial provisions and enforcement of this code. As I said, that was a very big discussion, so Chiara can tell us a bit about how it was resolved, but also what some of the other options might have been, so that you can see the kinds of things delegates were debating. Chiara, over to you.
Wonderful. Thank you very much again. Thank you for having me, and thank you very much for inviting me to present this on this important topic. I am sharing my screen, and I hope you can see it. Wonderful, excellent. So as Meg suggested and introduced, I will be talking about the compliance with the code, and as Meg mentioned during her presentation, that is provided in Article 12 of the code. And it's interesting coming after Michael's presentation, because I thought that really what Article 11 has in terms of details on disclosure, Article 12 actually lacks in terms of details. Article 12 tells that an arbitrator, a former arbitrator, and a candidate must comply with the code, and that the candidate shall not accept an appointment, and an arbitrator shall resign or recuse him or herself from proceedings if they think that they're not able to comply with the code. And then paragraph 3 is really the most important one in terms of compliance, in terms of saying that challenges and disqualification of an arbitrator or any other sanction or remedy is governed by the instrument of consent or the applicable rules. So Article 12 provides some information about the compliance with the code, but doesn't really provide much information in terms of implementation, enforcement, and sanctions. It provides some, but not very much. If you think about the status quo of the implementation mechanism now, we really have the arbitrators themselves must comply with the code, so it is left to the arbitrators themselves to ensure compliance. The enforcement of the code itself is done through existing mechanism, through either challenges or the recusal by the arbitrators or possible other applicable rules. And the code so far has provided a voluntary adoption. This is a little bit in maybe different from what the UNCITRAL Working Group 3 began with, because when the discussions occurred, the beginning of the discussion of the code began, the idea was to provide a code that was compulsory and not voluntary, that it was preferable to provide a mandatory compliance. But that discussion really was postponed. So we now have the code, but we don't really have an implementation mechanism that is provided with the code itself, or an enforcement mechanism that is provided with the code itself. So I thought it would be interesting to think about what mechanism could be envisaged that we can think about to ensure compliance and enforcement as the process of ISDS reform continues. In a draft note on implementation that was included in the initial discussion on the implementation and incorporation of the implementation and enforcement of the code itself, there were 4 options that were really highlighted. One is implementation by agreement of the disputing parties. 2, incorporation in an investment treaty. 3, an incorporation really through procedural rules of arbitral institution. And the 4th, by incorporation into any judicial standing mechanism. You see that I bracketed the text there, but I want to mention this because this is not a viable option anymore, but we should remember that when we think about the code, there was a decision to essentially partition the 2 codes and have a code for arbitrators that is valid now, and a code for a possible standing mechanism to possibly be created for judges in a multilateral investment court. This has been frozen. That discussion, the code exists, but the development of the code and that incorporation into a judicial standing mechanism has been postponed to a later stage of the ISDS reform. So if you're thinking about by agreement, so looking a little more at the first 3 options, by agreement of the disputing parties is what arbitrators, what is really happening now. So the parties are always, at any time, free to decide to apply the code and incorporate the code in their disputes. The code is there, it's available, and as Meg suggested, is a soft law instrument now, but the parties can use it. They can decide to use it at any time. However, deciding, so for the parties themselves only to use it, leave it, of course, provides a certain freedom to the parties, but does not ensure a widespread implementation of the code by itself. So it's probably better to think about other possibilities of implementation. One is the implementation through treaties. During the renegotiation of a bilateral or a multilateral treaty, parties can decide to implement, incorporate the code in their treaty. This is one option, and it could exist both for bilateral and multilateral treaties. A possible alternative option is also to create a standalone multilateral treaty. Let's call the Mauritius Convention model that we use to incorporate the transparency rules in both existing and in future investment treaties. This was done, of course, through UNCITRAL, and the parties agreed to apply the transparency rules that enter to treaties that also enter into force prior to 2014 or through the Mauritius Conventions for treaties that enter into force after 2014. This would ensure, this implementation mechanism would ensure a widespread application, but it will include, it will probably require, in terms of bilateral and multilateral treaties, a long time, but possibly also using the Mauritius Convention model, it would require probably a long time. And the question, there's a query whether there is support by the contracting states, by UNCITRAL members, and in general by members of the international community and those at Working Group 3, whether there is sufficient support for that. One of the issues is also uniformity in terms how will the code be applied after it is incorporated into treaties. A different option is implementation by institutions. Adjudicators can include it, so institution could, for example, include the code into the disclosure declaration as an annex to the disclosure declaration, into the procedural rules of the arbitral rules or in regulations. Query then is which institutions will institutions that have been negotiating, for example, the code, have been very much involved into the code, like ICSID and UNCITRAL, be the first ones to include it, or how about others? Will there be a uniformity then also in the application of the code? And how do you ensure uniformity if each institution have maybe a different way to then enforce the treaty? Regardless of what the mechanism for implementation will be, there will still be an issue of how to enforce the code itself. So when you think about Article 12, what Article 12 really does is to identify three interrelated issues: the issue of implementation, the issue of enforcement, and then the issue of the sanctions. What are the available sanctions? And these were all, the three of them were really unresolved during the negotiation. So far I spoke a little bit about the implementation, the different options that exist, the voluntary one, which is the one that is now that now exists. The second is via treaties of different ways, bilateral, multilateral, or possibly the more desirable way through a Mauritius-style treaty, or through implementation through institutions. It is important also to say that it is both, all these implementation mechanisms can coexist in parallel, and they can all be part of an implementation effort of the code. And so, but once the implementation exists, when we have the code that is incorporated in instrument, the issue still remains on how to enforce it and what is the institution that may enforce it. And so one possibility that was discussed, and I think it would be interesting to think about a little more, is to create or mandate an international organization to function as maybe the secretariat of the code, or as the center of the application, implementation of the code. Having such international organization or such instruments, such institutions mandated with looking at the secretariat, looking at the code, or the implementation and enforcement of the code, would ensure consistency of the application of the provisions of the code itself, possibly will reduce competition among institutions on how the code is applied, and would guarantee also widespread implementation. It needs, of course, coordination, and it is also possible there's some rules are not consistent depending on the different institutions. For example, if you look at issues of challenges, it will need to be negotiated and found, if a proper house being found. But we are in the middle of a reform process in the ISDS, and I think it will be important to think about creatively about how to enforce and implement the code that we have spent so much time to negotiate and agreed upon. So what are possible examples in terms of international organizations that may take up this role of enforcing, of being the center of enforcement of the code? It's possible, of course, to have an arbitral institutions, and this will be the home of having one institution being the center will be very important. UNCITRAL, of course, could play a role, an important one also because it's at the center of the reform process. We also may use existing international organizations. The World Bank, for example, has a very important ethics office and integrity office that plays certain similar roles, and we may think about something similar there. And during the discussion at the Working Group 3, there were some representatives that also discussed the possibility of having one of the international administrative tribunals possibly play a role, those that exist in all international organizations, the World Bank, the IMF, and of course, the United Nations. So I think it would be important to think about how to implement, how to enforce the code. And then, of course, my last point, and very briefly, because I know that we don't have a lot of time, but what are the consequences of the violation? What are the available sanctions? In the Code 9, Article 12, we talk about when an arbitrator is challenged or recuses him of herself. And this is really very much kind of the nuclear options, is either we don't do anything, or the arbitrator has to leave, is challenged with the result that he or she cannot sit in the arbitration, or the arbitrator also recuses him or herself because it's not because he or she thinks that is not it is not sufficiently independent and impartial. There are, however, ways, and Article 11.8, for example, already provides that there are some issues there, or non-disclosure, for example, that don't necessarily establish a lack of independence and impartiality. So what are some possible other sanctions that may exist that we can think about, again, as we think about how to implement and enforce the code? Can we think, for example, about certain financial sanctions, reduced remunerations for those violations that will not result in a full, in the finding of lack of independence and impartiality, but will be, let's say, a minor violation, or reputational sanctions, for example, reporting or publications. I think now that we have the code, it will be important to think about all of these issues. We have several years until the reform process ends, and I think it will be important to think and interesting to think about all of these issues in a way that would resolve some of the issues that have been left really pending through the Article 12 that provides only very limited implementation mechanism. So thank you, and I don't know if you have time for questions, but thank you for your attention.
Thank you, Chiara. I think I'm going to turn over to Anna. I want to give her the last word and get us concluded, and then to coffee break. Anna obviously was the UNCITRAL Secretariat leader on this, and so you may have a few thoughts, Anna, if you want to just add those, and then we'll conclude.
Thank you. Thank you very much, Meg. Indeed, it's nice to remind that it's a joint effort that has taken place among the two secretariats, but also among the member states, and that this discussion has resulted in a text that is now going to be implemented as follows. And I want to be very clear on that we're not going to revisit the code at any stage. We are going to work on its implementation in various ways. One is, of course, by the use by arbitral institutions, and I understand from ICSID that there's going to be a consultation with member states in order to make it an annex to the disclosure agreements or the agreement signed on by the arbitrators. As far as the UNCITRAL process is concerned, it's obvious that the Code of Conduct is the first reform element, and that it's not an isolated reform element in so far as it's going to be included into the framework convention that will deliver on the application of the various reform elements to the existing and to the future investment framework directly through the treaties. So I think from that point of view, there's not much question there. It is more a way forward that has been defined clearly. The Code of Conduct is adopted. It is there for the time being as soft law. It is there for parties to use. I understand from the ICSID Secretariat that parties are already referring to it in their disclosures, in the due diligence that is carried out by arbitrators that are being approached by parties for cases, and its inclusion into existing and future treaties will then ensure that it becomes part and parcel of the instrument of consent by the states to proceed to an arbitration. So that's really what I wanted to clarify, because there are lots of questions that are being asked, but I think that it's important when we are at the stage we are at currently to be factually and concrete and correct on what is the status of the code now. So the code has many provisions, as we have heard, and it was very illustrative to hear from experienced arbitrators and practitioners the way they understand the way the code, its text itself, and the commentary, which, as Michael Nolan said, is practice in UNCITRAL. It made me smile when he was explaining that a lot was in the commentary and a lot was found there, because a lot of the issues that didn't find their way into the code ended up in the commentary. So it's really important to read the two texts and to use them together. So very, as a concluding note, I just wanted to thank all the speakers, and of course my friend and colleague Meg for having organized this panel that promotes our joint code of conduct, that has given some insight and some indication about the content of the main provisions of the code, and also an understanding from learned arbitrators and practitioners on how they view this as a major step towards reestablishing confidence in the investor-state system, whether the issues that, or the concerns that are expressed or perceived are factually correct or not. What is important is not only justice to be rendered, but justice to be perceived to be rendered. So thank you very much for this very enlightening panel, and for the colleagues in ICSID for the continued promotion of this joint text. Thank you very much.
Thank you. I'll turn it over to the moderators to thank the audience.
Thank you, Ms. McKinney, and thanks to all distinguished speakers for the excellent presentations. Please allow me to introduce myself very briefly. I am Mayumi Komoto, attorney at the Litigation Bureau of the Ministry of Justice of Japan. I am acting as a program moderator for the Session 1. So thanks again to Ms. McKinney and all the distinguished speakers. Please give a big round of applause to Ms. Kinya and all distinguished speakers for panel 1. With this, we conclude panel 1. Now we have about 10-minute break before panel 2. Panel 2 will start at 11:15. Panel 2 will start at 11:20 a.m. Japan Standard Time. Thank you. We now proceed to panel 2. In this panel, we will be discussing the ICSID rules, annulment, and enforcement. Panel 2 will be moderated by Ms. Geraldine Fisher. Ms. Fisher is the senior legal counsel of ICSID and has been at ICSID for over 10 years and serves as the tribunal secretary on dozens of cases. We are also honored to have 4 prominent professionals in the field of investment arbitration as speakers of the session. Ms. Fisher, it's a great pleasure and honor to have you, and the stage is yours.
Thank you. Can somebody help me get the PowerPoint on, please? So thank you. I'm delighted to be here today to represent ICSID and talk to you about the new ICSID rules, as well as trends in annulment and ICSID award enforcement with our excellent panel. So for our panel, we have Mr. Andres Jana, who is joining us online. Andres is the founding partner of Jana and Hill Dispute Resolution. He is also the chair of UNCITRAL Working Group 2. We have to my left Mr. Lars Markert, who is a partner at Nishimura and Asahi. Further to my left, we have Mr. Pierre-Olivier Savoy, who is a partner at Savoy Arbitration. And on my right, we have Ms. Yoshimi Ohara, who is a partner at Nagashima, Ono, and Tsunematsu. So first, I'd like to give you a brief overview of how the new ICSID rules came to be. The new ICSID 2022 rules were developed over 5.5 years through extensive consultations with member states, arbitrators, counsel, civil society, academics, and other facility users. There were several overall objectives for the new rules, including to address time and cost concerns, to increase transparency of the process, to respond to procedural aspects of the ongoing discussions about reform of ISDS, and to give parties more options in terms about how they could resolve disputes. So we have updated conciliation, fact-finding, and mediation rules. The new rules were resoundingly approved by ICSID member states and came into effect on July 1st, 2022. Today, we're going to focus our discussion on case management conferences, CMCs, increased transparency, and the expanded additional facility and mediation under the new rules. We'll also talk about recent trends in annulment and enforcement of ICSID awards. So for format, I'll give a brief introduction of each topic before turning the floor to our speakers. So Rule 31 deals with case management conferences. It was introduced to reduce the time of proceedings by encouraging arbitrators and parties to be proactive. Under the new rules, tribunals must hold 1 or more case management conferences with the parties at any time after the first session to identify uncontested facts, clarify and narrow the issues in dispute, or address any other procedural or substantive issue related to the resolution of the dispute. So there's a lot of room here for innovation for CMCs. At ICSID, we have seen an increased use of CMCs, which have been primarily held by video conference, but you can also hold them in person, and then some people hold them by telephone. Tribunals have used CMCs to discuss various topics like document production, evidence, streamlining issues, procedural calendar, and the scope of future submissions. On CMC timing, some tribunals prefer to schedule out CMCs at the first session to have programmed times to discuss issues with the parties. Many times, a CMC will be held after the first round of submissions. So now I'm going to turn the floor over to Andres, who will discuss how CMCs can be used in a flexible manner to make proceedings more efficient including the types of issues that can be addressed. Andres will also explain the benefits of active case management. Andres.
Thank you very much, Jerry. I'm grateful to the Ministry of Justice of Japan, UNCITRAL, and ICSID for the invitation. Regrettably, this time only virtually. I would say there is a significant trend in general international arbitration and increased expectation that the tribunal will be involved in the management of the dispute at an early stage and make the parties and counsel collaborate in the effort of streamlining the dispute with respect to facts and the matters to be resolved. Article 31 reflects that trend and expectation, and I would say that reflects it with a prescriptive language, because it said that the tribunal must hold one or more case management conference. And also Article 31 provides guidance on how the case management conference could be used or what type of issues can be addressed, as you already read, Jerry. So what I would like to do in the minutes that I have is first explain or present in the application of Article 31 what are the different moments in which a case management conference can be held or are frequently used, and what type of matters are addressed typically in these different opportunities in case management conference can be held. First, as the case management conference can be held together with the first session or right after the first session at a very early stage of the proceeding. I would say that this case management conference is particularly useful to address a matter that investment arbitration is frequent or reasonably frequent, which is Article 41 objections of manifest lack of legal merit of a claim. Also can be used to address at an early stage issues of evidence. And I would say something that could be used, which is less frequently used, and I will come back later, is the possibility of encouraging parties to reach or to reach a settlement or to enter in a possible amicable procedure in parallel to the arbitration. Then a case management conference is, I would say, is very useful after the filing of the memorial by the claimant. In this moment, I would say that it's typical the case management conference can address issues of preliminary objections raised or objection to jurisdiction raised by the respondent, and the possibility of some or all of these objections, the possibility, of bifurcate some of all of these objections. Then, a moment that I would say that is particularly helpful to consider a case management conference is after the first round of pleadings. After the first round of pleadings, I would say it's typically that the tribunal can give guidance on the production of documents, the scope of issues to be addressed in the second round of pleadings, or to require the parties to work jointly in a chronology of the disputing of the dispute facts, especially on non-contested facts, and even the tribunal can do it in a dynamic document, which means that this is a document that can be evolved during the proceedings, incorporating new non-contested facts. In addition, something that is a trend, I would say, in complex litigation that require technical expertise, you see also that the tribunal likes to involve experts, or the expert be involved at an early stage of the proceeding, trying to identify common issues of expertise, or even joint reports to narrow the matters where there is disagreement among the different experts. Another Another aspect that I would like to refer in which I think there is an interesting aspect of case management is the bifurcation related not to issues of jurisdiction, but to substantive issues. One of them that has received recent attention, and I think it was something that will receive more attention in the future, is the possibility of bifurcating liability and damages phases. I know that liability and damages phases is something that is not uncommon in terms of bifurcation in ICSID proceedings, in investment proceedings. But I think what is interesting in this trend is the possibility that that bifurcation would occur at a much early stage of the proceeding, avoiding the preparation of expert reports that in a number of cases have to be significantly revised after a partial award by the tribunal on liability. So in that case, the tribunal will make the bifurcation even before these expert reports have been start to be prepared. So, and of course, this would depend heavily on the individual circumstances of the case, such as the issues of liability, claim, and how relevant are the damages to decide on those issues. I just would like to refer to a couple of cases where this has been the case. One is the case of Glencore against Bolivia, that the tribunal even motu proprio or ex officio decided to promote this bifurcation. And the other, which has a very interesting reasoning about the different competing elements to decide and bifurcate or not at an early stage the liability and damages, is the case of Gran Colombia versus Colombia. Finally, another procedural moment where case management is valuable is in the preparation, obviously, of the hearing, where the tribunal at the post-hearing conference can have a much more active role on the issues of marshalling the evidence, but also putting questions to the parties to be addressed during the hearing, or that the parties would prepare a joint list of issues of the tribunal to be resolved and discussed during the hearing. Finally, as I mentioned very briefly before going to the benefits, something that maybe would be interesting to see more often in the case management as a case management technique or tool is that the arbitral tribunal will recommend or invite the parties, when the circumstances so justify, to explore amicable resolution procedures at the time of the arbitration, which, when, as I said, would allow the parties, notwithstanding that an arbitration, to try to come up with or try to explore the possibility of settlement. That again I think is something that you hear increasingly, because alternative dispute resolution mechanisms such as mediation are, in the agenda in order to make proceedings more efficient. So going to the final point very briefly, what are the benefits of an active case management? Well, obviously, the first benefit is efficiency, right? Which is the saving of cost and time, which is something that is not just important in itself, but also help for the legitimacy of the entire arbitral process. Parties often complain about arbitration being costly and timely, and in particular investment arbitration. But I would say that is not just time and money or cost, it's also the quality of the decision of the dispute overall. If the arbitral tribunal has a better understanding of the dispute and the factual and legal issues before it, if the parties plead their case and present evidence in a more focused fashion on the relevant matters under the guidance of the tribunal, certainly the outcome of the arbitration under the resolution of the dispute will also be better. In finalizing what's just one final point, it's important to remind that case management conference is a tool. and as a tool, is a tool and not a goal in itself. Therefore, it's very important, obviously, to look at efficiency and cost, but also it's very important, especially in investment arbitration, where a state is involved as respondent, to also look at issues of fairness and take into consideration the position or the particular position of a state. Having said that, in my conclusion, the benefit of a case management conference is not only a tool for procedural efficiency, but also a tool for a better and more fair resolution of the dispute as a whole. Thank you very much.
Thank you, Andres, for highlighting the benefits of this very flexible tool that can be used not only for enhancing procedural efficiency, but also possibly used to help come to some sort of resolution in cases, as well as to focus issues that are really in dispute. So now we'll move on to the next topic, which is transparency. So the new rules also extend transparency in the arbitration proceeding. Awards will continue to be published with the consent of the party in ICSID convention cases as required by the convention. But if neither party objects within 60 days, their consent to publication is deemed to have been given. If there is an objection, ICSID will extract the legal reasoning as it has done in the past. All orders and decisions will be published during any arbitration or post-award remedy proceedings, and these will include redactions agreed by the parties, and the tribunal will decide any dispute about the redactions. The amended rules also allow for the publication of a party's own main pleadings by that party, with any redactions agreed by the parties or decided by the tribunal. And there's also open hearings unless either party objects. The new rules have also added provisions for non-disputing party and non-disputing treaty party participation. Any person or entity that is not a party to the dispute can apply for permission to file a written submission in this case. The rule added 2 criteria for NDP participation. You have to identify the non-disputing party and affiliation to a party, and whether the NDP receives funding or assistance from the party. This rule reflects current practice. A state which is not a party to the dispute, but which is a contracting party to the treaty, can make a submission on certain questions as a matter of right. These submissions are limited to the interpretation of the treaty. So we'll both have Pierre-Olivier and Lars talking about this topic. Pierre-Olivier will present on the benefits of transparency in ISDS. He'll also delve into when an NDP amicus should be allowed to participate in a case, and what an NDTP brings to the case. That's a non-disputing treaty party brings to the case. And he'll also give us some pointers on how to avoid this process, adding time and cost to the case. And then Lars will chat about the benefits of expanding the transparency requirements to cover decisions and orders, and how disputing parties can prevent disclosure if they do not want documents or hearings made public. So I'll turn the floor over to Pierre-Olivier first, and then Lars.
Thank you very much, Jerry. It's a pleasure to be here today. On the advantages of transparency in ISDS, ISDS and arbitral dispute resolution are markets. And for a market to work well, it's fundamental that the market be as transparent as possible. That's basic economics. If you have a non-transparent market, unfairness may result. Access to awards, pleadings, procedural orders, decisions, arbitral appointments, the name of counsel, is extremely good for a fair and well-functioning system. Secondly, since ISDS concerns public goods and state expenditures, it's also usually good for the public to know how their money is spent on a case if it's settled or lost, and to know what the state does when it regulates, which in principle is supposed to be for the public good. So transparency, in principle, good. I'll leave it to Lars to go into some of the other details with respect to the intricacy of the rules. On the second question, new Rule 67 allows for non-disputing parties to request making a submission. There's no right to intervene. Those provisions which have existed in a form or another under other rules for almost 2 decades have not been used extensively. 2 early examples are in 2000 and 2002, where NAFTA UNCITRAL tribunals, first in Methanex versus the US and then in United Parcel Service, or UPS, versus Canada, accepted to admit written submissions of third parties. In Methanex, it was the International Institute for Sustainable Development, IISD, and Earth Justice. In UPS, it was the Canadian Union of Postal Workers and the Council of Canadians, a public interest NGOs. The parties also agreed to make case documents available to the intervening parties subject to redaction of confidential information, which is helpful if you want the non-disputing parties to actually have something useful to say about the case. The reality, however, is that parties to the dispute can usually, but maybe not always, put the issues well to the tribunal. But there are instances, are there instances, for example, where a trade association, trade union, NGO would have a particular interest and specific and useful factual information in the dispute for the tribunal? The criteria to intervene are set out in Article 67, and they include not disrupting the proceedings, being useful, having a particular perspective on the facts or the law. So really, it's a question of the facts, on the facts. I'm kind of wondering in some of the cases that against the Netherlands, which apparently will not go forward on closure of coal plants, for example, if they had gone forward and if there was a serious question about compensation after ordering to close coal plants maybe a decade before the end of the planned project, would it have been interesting or useful to hear unions, workers, about how compensation had an effect on transition of jobs, pension funds, and the interrelation between climate change and those issues? I will conclude now or move to the last topic, which is Rule 68, which I think is one of the most important additions to the 2022 ICSID arbitration rules. It gives non-disputing state parties to an investment treaty an automatic right to intervene in cases and make submissions on legal interpretations, not the facts of the case. So under applicable rules of interpretation, tribunals must take into account agreements on interpretation which can arise from practice, such as interpretive statements. In 2011, the Ontario Court of Appeal in Toronto held that if there's an agreement on interpretation of treaty parties, in that case NAFTA, on a jurisdictional issue, and the tribunal disregards it, this may yield to setting aside the award. There's been extensive practice under NAFTA for 20 years, with the US, Canada, and Mexico making many interventions and reaching on a number of issues agreements on interpretation, though not always. For example, in Cargill versus Mexico and Mobile versus Canada, a divergent US interpretation on a NAFTA provision led, in my view, to a result that was favorable to the US investor. Issues on which states may intervene include the meaning of substantive provisions such as fair and equitable treatment, indirect expropriation, whether a continuous breach of international law can defeat a 3-year time bar found in an investment treaty, whether certain preconditions to arbitrate are jurisdictional in nature, whether the conditions on the proper exercise of police powers in the context of an indirect, what they are in the context of an indirect expropriation. Last summer, for example, I did a case defending Romania, where Canada intervened on a number of interpretive issues, and there were several agreements on interpretation put to the tribunal. One example was that a new BIT concluded between the two countries in 2009 terminated the 1996 BIT and created a 3-year period to put forward claims under the old treaty. And that was considered by the two states to basically terminate the sunset clause, but somehow the investor did not agree. So there were submissions on whether what was the effect of the agreement between Canada and Romania that the sunset clause was terminated by the new treaty, which has been put to the tribunal, who hasn't decided the case yet, but that should come out in the next year or so. So But not only do non-disputing state parties have an automatic right to intervene to make submissions on interpretation, but the following addition to the rule is very interesting. The tribunal may, after consulting the parties, invite a disputing treaty party to make such a submission. So the tribunal may invite this to happen. So let's run the possibility of an intervention from three perspectives: respondents' counsel, investors' counsel, or a member of the tribunal. If I'm respondent counsel and the other treaty party or parties have a right to intervene, one of the first things I think the respondent should consider is check in with the other state if they're considering to intervene, and if so, on what legal issues. If I'm counsel for the investor, then I think it's important to see with the state of the investor's nationality if they intend to intervene and what would be the legal issues they would consider. A conversation probably needs to be had. And if I'm sitting on the tribunal, why not ask the other treaty parties at the outset of the case if they plan to intervene? This allows to pencil in to the procedural calendar the possibility of intervening to avoid disruption in the middle of proceedings when a state shows up and says we're interested to intervene. You need to consult the disputing parties, of course, but doing it right away, if anything, can avoid later disruption. So how do you set up a procedural calendar to make sure that the case is not disrupted with such interventions? An intervening state should show up at least to reserve its right to intervene before the procedural calendar is set. So just around the time of the constitution of the tribunal. For an ICSID case, that's easy. You just need to check the ICSID website. Updates on procedural details occur almost in real time. The interpretation submission of the non-disputing treaty party will usually be made after all the substantive pleadings in a phase and before the hearing in that phase. Say you have a jurisdictional phase after the memorial, counter-memorial, reply, rejoinder, the state intervening would make a submission, say 30 days or maybe 45 days after the last pleading on a legal issue. Usually they're relatively short submissions, maybe 5, 20 pages, no facts, only law. So then the disputing parties would have another short period, maybe 30, 45 days, to make written comments on that submission on the law. And then you have the hearing. In NAFTA cases, sometimes intervening states made very short oral submissions at the hearing, 5, 10, 15 minutes. To have some weight, interpretive submissions should have a level of consistency. If a state has been saying the same thing on a particular issue dozens of times over the last decade or two, just to give an easy example, Canada has been saying exactly the same thing on how it interprets the time bar time and time again, then I would think that a further submission that is consistent with that should attract some great weight. Not all tribunals, however, seem to think that. For example, in Infinito Gold versus Costa Rica and Eco Oro, the tribunals somewhat disregarded the questions. The Canada's interpretation. So in terms of the importance of consistency of positions, I can point, for example, those interested to the International Law Commission's 2018 draft conclusions on subsequent agreements and subsequent practice in relation to interpretation of treaties. So those draft conclusions from the ILC are useful. So if we're serious about ISDS reform, I think this is absolutely key. My understanding is that no state yet has availed itself of this possibility outside of treaties already having that possibility, such as NAFTA and the USMCA. There are 78 cases that have been registered since August 2022. 7 are contract cases, 2 investment law cases, so those are outside of the scope of Article 68, but you still have 69 other cases. 28 of them are under plurilateral treaties, 12 NAFTA USMCA, 10 Energy Charter Treaty, to which Japan is party, 3 CAFTA DR, 1 CPTPP, and 2 other Central American FTAs. And aside from that, you have 41 other BIT cases which involve 20 different countries of the nationality of an investor who could have an interest in intervening. And the states are very diverse. China, France, US, Mauritius, Canada, Lithuania, Malaysia, Spain, UK, Libya, Latvia, Germany, Korea, Italy, Switzerland, Netherlands, Albania, Turkey, Mexico, and Belgium, Luxembourg. So if states really want to participate in the system, the door is wide open.
And what about the issue of costs? Sometimes parties raise the fact that costs could increase with that participation. How would you mitigate that?
Well, they will, but if you have a submission on law which is 5 to 10 pages, I mean, you've already had 4 rounds of submissions where each party has said certain things on, I believe the law is this. Then you have the other party to the treaty, or maybe, okay, if you're under the ECT and you have 50 interveners, that could be a problem in terms of costs. So that can perhaps be managed, but you will basically look at what the state says and say, I agree with what they say on interpretation, or I don't, or what is the consequence? The other thing that people argue is, what are the consequences of an agreement on interpretation? If you're an investor, you could say this is opportunistic. I don't think you should take it into consideration for whatever reason. But if you've already spent 2 years litigating those legal issues, you know, if you put a 30-day deadline, you're not going to spend more than 30 days on it. So, and in principle, you're supposed to know what you're arguing.
Great. Thank you so much. Now over to Lars.
All right. Yeah, I'm going to address the benefits of publishing decisions and orders. And that is somewhat novel, because previously you only found those when you were looking for them if there was already an instrument of consent that already obliged states to publish those, or the investor. And so this is quite nice. It's quite a nice new development, because when you think about it, before you had to parse the published arbitral awards to find the procedural issues that you're interested in. And the awards normally would only refer to larger procedural issues, but not the smaller ones. So I remember parsing through NAFTA cases, because in the NAFTA cases, you often find procedural orders on document production, and you would try to pick out certain standards from that. And that will now become much more prevalent. And so I think this will be very helpful, because it creates a different kind of case law than we had before. Before, we had kind of the substantive case law and the procedural case law insofar as it pertained to specific issues of jurisdiction and admissibility, but you didn't have the smaller procedural battles accessible. And I think that, in a sense, leads to a democratization of ICSID procedural practice, because before, you had the big law firms. Of course, they were doing that as a serial matter. They were running those cases, but now it's open to everyone. And also firms that are not doing this on a everyday basis, they'll have access to that. And I think this is really helpful. And just maybe also a comment on costs. When we think about them, what does that mean for costs? I predict that having this published might eventually lower costs, because parties will not pick procedural battles if they know, based on public orders and decisions, this is a losing battle. Or it might streamline the fight about these procedural orders, because you will know from various tribunal decisions how those procedural issues have been addressed, how they have been streamlined, and how they have been decided. So I think that's a very good development. I think the second question is an interesting question. It's how can disputing parties prevent disclosure if they do not want documents available or hearings made public? And here, I think ICSID has come up with a very detailed way, and the way you can kind of prevent publication really depends on the stage or the document you're trying to prevent. So for awards, as you said in your presentation, if there's no consent, there's no publication, but then ICSID will resort to publishing excerpts of the legal issues. And that is really something ICSID couldn't really change, because that's in the ICSID Convention in Article 84, subsection 5, 48, 5. Of course, if you're under the additional facility rules, the ICSID Convention doesn't prevent that. So there is the possibility to publish that. Other orders and decisions we just heard in your presentations, they will be published automatically. And so there the battle will not be about is it published or not. The battle will be about the redactions. So still you can have redactions if you as a party feel there is certain information you don't want to see published, and you can take this up and fight about it, and in the end the tribunal will decide what can be redacted. And I'll address the arguments why things should not be redacted at the end. Then when it comes to supporting documents, that's the Rule 64, and supporting documents can be witness statements, expert reports, exhibits. They will only be published with the party's consent. And looking into in a sense, history of that rule, and you look into the working papers, I think there was quite a debate about this, and with some states saying, yeah, we should publish this, and others said, no, this is going to be subject to a lot of fights about redactions. And so I think the ultimate solution was that it needs joint consent. Hearings, if you're not comfortable as a party, you can veto public hearings. So if you're not comfortable, that is easily done. And again, there was also some discussion during the preparation of the rules whether that should actually be broadened, and make it more difficult to object to not having hearings public. But that's what in the end the states came out with. So now, interestingly, all of that is subject to Article 66, which provides grounds for why you do not want to see things public. And there are various grounds. So if your instrument of consent already prescribes confidentiality, of course, that should not be made public. I think the most interesting one, the reasons why something should not be published is, of course, the agreement of the parties. So if both parties agree, and that I've seen that happen, that actually both parties were quite happy with things not being out in the open. I worked on one ICSID case, the award is still not published. Then there's no publicity. And of course, commercial sensitive information, you can ask for redactions. So I think you can be pretty comfortable that things are not made public what you're not comfortable with. I think the one interesting standard that I want to see how it's going to play out in practice is 66F, which is a state can say, I have an essential security interest. And that seems to be a subjective standard. So it's enough for the state to invoke the security interest. So I think in practice will be very interesting to see whether this will be abused or interpreted very expansively, and what then tribunals or ICSID will do with that. So I'll stop here. Thank you.
Those are some great points, and I think you canvassed the transparency provisions in an excellent manner. So thank you so much. Okay. So we'll move on to our next topic, which is broader access to additional facility, the additional facility rules. With the 2022 rules, the additional facility rules were updated. The real change to note here is with respect to jurisdiction. In particular, the new rules significantly broaden access to the additional facility in two main respects. First, additional facility cases can now involve parties that are both from non-ICSID member states. They're no longer limited to cases where one of either the claimant or the respondent is from an ICSID member state. Second, an REIO, which is a Regional Economic Integration Organization, can now be a claimant or a respondent in an AF case based on its consent, which can be in a treaty or in a contract. This change reflects the fact that increasingly states are negotiating international investment agreements as regional entities and may sign an IIA as an REIO. In fact, in October of 2023, ICSID registered an additional facility case against the European Union. So we will have our tag team of Lars and Pierre-Olivier again on this topic. Lars will lead the discussion on the impact of expanded access to the additional facility and how it will impact potential users, and discuss any specific considerations that may come up in the context of a case by or against an REIO. And we'll have Pierre-Olivier look at the benefits of using the AF rules over other arbitration rules from a party perspective. So I'll turn the floor over again to Lars. Thank you.
Thank you, Jerry. Well, the first impact is, of course, almost what Jerry already has said, is that there's much broader access now to the additional facility rules. So neither the state of the investor nor the host state or the respondent state need to be parties to the ICSID convention. So that opens a much broader scope of using those additional facility rules. And in a sense, with that, they will become a true competition to the UNCITRAL rules that have been previously used when you were in that situation that on one side there was not a member state to the ICSID convention. And of course, and I'll address this in the second prong, now you can involve an REIO. And coming from Germany and the European Union, of course, when I read REIO, I actually read EU. And that's probably not quite fair, especially not in Asia where there might be others. But I think the first use case that Jerry just mentioned is involving the European Union. So much broader access. In a sense, you have a bit of a competition to other arbitration rules that have been prevalent before. And I think Pierre-Olivier will discuss this a bit more in detail. I just want to discuss one aspect that's very ICSID related when it comes to additional facility rules versus ICSID arbitration versus UNCITRAL rules. And that is the definition of investment you have to fulfill when you bring an ICSID case under Article 25 of the ICSID Convention. You sometimes had it happen that the parties purposefully did not choose the ICSID Convention and the ICSID arbitration rules because they were concerned that the investment they had made might not comply with what is understood to be the notion of investment under Article 25 of the ICSID Convention. And so people in those cases choose purposefully the UNCITRAL rules because then your investment only needs to comply with the instrument of consent, so the BIT, for example, but it doesn't need to comply with what is generally known as the Salini test that ICSID tribunals now employ quite often. So people went and chose the UNCITRAL arbitration rules, but some investors were quite surprised when tribunals acting under the UNCITRAL arbitration rules suddenly invoked the Salini test that's prevalent for ICSID tribunals and started checking whether this is an investment, a proper investment. And this has happened in the Romak versus Uzbekistan case in 2009, so that dates a while back, in the Alps Finance case versus Slovak Republic in 2011. It more recently happened, even though the case wasn't dismissed, in the Gramercy Funds case versus Peru. So that is the surprise. So now what happens if you have the additional facility rules, to come back to that topic? Could one say, well, if you're going with the additional facility rules, then of course you somehow have to look to Article 25 of the ICSID Convention when defining the notion of investment. And interestingly, if you look at the changes that have been made to the additional facility rules, I think you can safely interpret the additional facility rules to mean that that is not the issue. So if you arbitrate under the additional facility rules, a party cannot invoke a jurisdictional objection to say you haven't complied with the definition of investment as it is to be done or fulfilled under a case under the ICSID Convention, so the Salini test. So the old Article 2A of the additional facility rules contained language that said you can use the additional facility rules if a case is not within the jurisdiction of the center. And so that reminds you immediately of Article 25. That has changed now under the new additional facility rules. That old article, and also in the old text, there was something directly arising out of an investment. That has also been taken out. So if you now read Article 2 and Article 3 of the new additional facility rules, 2022, it seems to be pretty clear that this was deliberately carved out. And if you actually look at the working papers, this issue has been discussed, and it was decided we need to make sure that there's no misunderstanding. There's no need for what is commonly called a double barrel or double, I think there's a more benign word for it, double barrel test. So you need to have a two-stage test. First, you need to see whether under the BIT you have an investment, and then you need to see whether under Article 25 you have an investment. The additional facility rules, the negotiation history make that clear. That is not required, at least in my view, that's pretty clear. And so, in a sense, if you go with additional facility rules, you're almost safer than with the UNCITRAL rules, because under the UNCITRAL rules, still you might have tribunals following precedent of other UNCITRAL tribunals that said we need to somehow read in the Salini test when we check the investment. Okay, let me jump to the Regional Economic Integration Organizations, the REIO, and check what specific considerations come up in the context of that case. And again, sorry that I approached this from the one known case that's already out there. That is a case, of course, dear to me because it involves not only the European Union, that's the one case against the REIO, but it also involves a parallel case brought against the Federal Republic of Germany and a third case brought against Denmark. And this is, I think, exactly where we see what can happen and what is very interesting. If an REIO regulates, performs acts that can be attacked by investors, normally it will not do so alone, but it will do so and it will be followed by the member states in that REIO. And in the EU, it's pretty clear. The EU basically legislates by way of directives and regulations. So if the EU issues a directive, the states have to implement. If the EU issues a regulation, normally that's already an act that's directly applicable in member states. But still, member states often have to implement and perform some implementing legislation. And this is exactly the case in the Clash. It's Clash versus a European Union case, where the EU issued such regulation actually to target windfall profit taxes arising from the rise of energy prices in following the Ukraine war, and targeted those. And so Clash says, you are taxing me too much. And it accuses the European Union of having taxed too much, but also Germany of having done that. And so coming back now to the additional facility rules, what do we do with these cases? That's extremely interesting. How do you run those two cases? Because the REIO case can be run under the additional facility rules. The case against Germany is run under the ICSID convention. So normally you would try to consolidate, but if you don't have two cases under the AF, the additional facility rules, or under the ICSID convention, that's more difficult. However, and here we come to a new provision in Arbitration Rule 46, which also allows for coordination of cases. So I'm speculating that this will be a prime use case for coordination of these proceedings. And so I think that is one of the considerations I see come up in the context of a case by an REIO, that governments, the REIO, investors, the institution, all have to give a lot of thought of how those cases can be coordinated to make them run efficiently. Thank you.
Some excellent points. Pierre-Olivier?
So excellent that I have to pick up on one of them. I think that what Lars raised with respect to clash is extremely interesting. With respect to whether you can say that under the ICSID additional facility rules you can avoid kind of inherent characteristics of an investment. Which is why sometimes claimants who thought they were in a more difficult position on those issues use the UNCITRAL rules rather than the ICSID convention. And just to make a link with what I was saying before, there's kind of a parallel between Article or Rule 68 in the AF rules, which is Rule 78, which allows also states parties to the treaty to intervene in an AF case. So all Energy Charter Treaty members could intervene in the clash case, and they could have a view as to whether or not basically the ECT has inherent characteristics of an investment or not, or if inherent characteristics of an investment are in all BITs. Our friends from the government here of Japan may have views on those issues as possibly the other 50 or so ECT cases. So there's a lot of very interesting issues that arise. In terms of advantages of using the additional facility rules, I had 6 points. One, there's the question of deadlines for an award, which second, there's the question of party autonomy in changing rules. 3, self-contained arbitrations. 4, sophistication of the ICSID rules. 5, just great secretarial support from ICSID. And 6, the question of cost. So on deadlines for an award, I think by contrast to the UNCITRAL rules, now the new ICSID rules and the new additional facility rules have specific deadlines for a number of types of decisions or awards. 60 days for an award on a manifest lack of legal merit question, 180 days on jurisdictional objection, and 240 days at most on all other issues. And for expedited arbitrations under Rule 85, it's 120 days. You don't have those types of deadlines except for expedited arbitration under the UNCITRAL rules, and even there it's 2 months more, it's 180 days for. So if you or the client wants strict deadlines for awards, which usually people like, except if you're going to lose the case, or if you think you will, then those things can be great advantages. Two issues that I think should be talked about together was party autonomy to change rules and sophistication of the ICSID rules. ICSID rules are extremely sophisticated on a number of issues, especially with the amendment, and they are absolutely great rules. On the other hand, there's a bit of a difference with the UNCITRAL rules, which they don't lend themselves as much to the parties modifying them at will, which is one of the fundamental principles of UNCITRAL arbitration. So depending on what you're looking for, there's a question there whether you want something that really looks like an ICSID arbitration, or you're at a sophisticated level where you're able to have certain conversations with the other side and try to modify procedure. So those are considerations. Third, self-contained arbitration. One of the advantages of ICSID arbitration under the convention is that you cannot go to annulment before the end of the whole process. I think, but I'll be careful about what I'm saying, but the way the additional facility rules are set up are somewhat similar. Even though it's an arbitration with a seat, even though with an interlocutory or jurisdictional decision, maybe you could try to go to the seat. But like the convention, and I did look at this issue about 15 years ago under the 2006 rules, and I had come to the view that it was probably difficult to interrupt an ICSID arbitration, an ICSID AF arbitration in the middle of it. And there's ways. You have only one award in those rules, so it's the same concept. And there are ways for a tribunal to basically insulate decisions from set aside potentially, where only the presiding arbitrator can sign it under Article 35(2) of the rules. And for example, if you try to set aside an award in France which has only one signature, it's going to be complicated because you need all tribunal members to sign it, or at least a majority. So that may be something. If you want to try to insulate, you have to be careful about it, but I think that could be something to consider. 5, as I said, ICSID additional facility rules, you will have great support from the Secretariat, who is used to handling very complex arbitrations. And on the 6th, there's the question of costs. And on costs, I think that for users of international arbitration generally, different rules come with different results in terms of costs, and you need to know what type of arbitration you have. I would say for a relatively large size investment treaty arbitration, ICSID is perfect. The annual costs, administrative costs, $52,000, if the Secretariat does a lot of work, is going to be a steal.
$26,000 per side.
Well, I know, but it's once the state starts chipping in, and the rates are flat rates per day. They've increased them $500 US an hour, but that's still very reasonable if you have a 500 million or a very big arbitration. If you're under one of the types of rules where it's proportionate to the cost, like ICC or Stockholm, it would be much more expensive. So for the right size of case, I think, and if you have an UNCITRAL case, it's the arbitral tribunal who sets the rates, which I assume is going to be much higher than the one set by ICSID. So you have all these variables which I think can lead you to want to choose the ICSID additional facility rules in the right case.
Yeah, that's great. Thank you so much. So there's a lot to talk about also on the additional facility, but the REIO element, very interesting. Thank you. So I guess we'll move on now to mediation rules. So in 2022, ICSID adopted an entirely new set of mediation rules. These are available between parties in a dispute relating to an investment, and the parties do not need to be nationals of a member state or a member state under the convention. The mediation can be started under an existing agreement or agreed to by the parties or an ad hoc basis, and the parties can agree to start the mediation at any time, including before an arbitration proceeding as envisioned by some treaties or in parallel with the arbitration. The mediation rules are aligned with the formal requirements of the Singapore Convention, enhancing the enforceability of resolution reached through mediation. So on this topic, we'll have Yoshimi and Andres. Yoshimi will explain the benefits and challenges of investor-state mediation and discuss the UNCITRAL guidelines on investment mediation. And then Andres will talk about the aspects of ICSID mediation rules that are particularly useful for promoting a successful mediation and what issues to consider when deciding whether to pursue mediation. So Yoshimi.
Thank you. Thank you, Jerry, for your kind introduction. So I'll start with the benefits of the investor-state mediation and challenge, and also introduce UNCITRAL guidelines on mediation for international investment disputes. So for those who are involved in commercial mediation, perhaps you don't need my explanation in terms of benefits, but I would identify nonetheless 3 salient benefits of use of mediation in investor-state dispute settlement. Number 1, cost efficiency and time efficiency of dispute resolution. In investment treaty arbitration, according to the study, on average, parties spend 4 years in an investment treaty arbitration, and investor and states respectively spend US $6 million, and for state, 4.8 million on legal representation, and on average cost of 3-member tribunal amounts to at least $900K US. Whereas mediation, sometimes, you have to have, the period for submitting statements, but mediation could be concluded within 1 day. The second benefit is preservation of relationship between the parties. Investment arbitration could burn bridge and alienates whole state. But mediation, party can continue the relationship and continue the ongoing investment business. And third, parties have more control over the outcome of the case. Why? because in investor-state arbitration, there's loser and winner. But in mediation, there's no loser, only winner and winner. And because it's a consensual procedure, enforcement of the consent is much more smoother and easier. And even if, in fact, mediation may not be successful, I think there's a benefit of having dialogue between investor and states, because in the course of unsuccessful settlement discussions or mediation process, parties may better understand each other. So these are the benefits, and now I move to the challenges. And I want to highlight the challenges, particularly relating to states. State parties are often reluctant to take responsibility for concluding settlement for primarily political reasons. And I personally involved in negotiation with state or state-owned entity. They are always concerned about possible accusation of corruption and audit. So they prefer to lose in investor-state arbitration rather than having settlement discussions or mediation and subject to potential criminal investigation afterwards. Second challenge is state official. It's not easy to obtain budgetary approval based on settlement arising out of mediation, whereas it would be easier for state to secure budget if it is based on tribunal award. The third, enforceability, settlement agreement, there was no mechanism of enforcing settlement agreement until quite recently, until the Singapore Convention entered into force. So Japan acceded to Singapore Convention, and I think it becomes effective April 1st, 2024. So those who are a member state of Singapore Convention, the lack of enforceability issue is no longer applicable. So I moved to the introduction of UNCITRAL guidelines on mediation for international investment disputes. So these guidelines actually help you decide whether to mediate, when to mediate, and how to mediate. So start with whether to mediate or not to mediate. The guidelines, identify a couple of points that you may wish to consider whether mediation, in determining whether mediation is suitable to settle any disputes between state and investor. For example, desirability of maintaining the parties' relationship, willingness of the parties to enter into dialogue, the complexity of the issue, urgency of the matter to be resolved. There are many more. Please check the guidelines. And next, when to mediate. So you may tend to think mediation should come first before arbitration, but in fact, mediation could be done at any time in the course of arbitration if parties so wish. In fact, sometimes it could be effective and efficient to have mediation in the middle of arbitration proceedings because, once in the middle of arbitration proceedings, because in the arbitration proceeding, parties submit pleadings and evidence, and each party appreciates the other party's position better in the course of arbitration, and there could be more incentive for the parties to sit and mediate. So never too late, consider mediation at any time in the course of arbitration proceedings. Third, how to have the successful mediation. So this guideline suggests the important elements of successful mediation. One is selection of mediator, second, attitude of the parties, third, role of institution, and many more that I'm not going to go into detail. First, mediation, a selection of mediator. Of course, we have to have mediator who appreciates intricacies of investor-state mediation. It involves more cultural aspects. and appreciation of the state's challenges that I just introduced. And second, in terms of parties' preparation and parties' composition of the parties' team to participate in to mediation, this is really important. To have the successful mediation, we have to have representatives of the parties who have authority to decide, who have authority to enter into the settlement agreement. When it comes to state parties, this is not easy. So this is exactly one of the challenges that investor state might have. And nonetheless, state party can create team members, at least who are relevant to the dispute settlement, and make the full house team to make sure that all the ministries or officials having responsibility in settling the dispute be at the mediation, so that they can directly hear, directly participate in mediation, and communicate with the higher authority within the ministry, for example, if necessary, and make the proper process to get the authorization in the course of mediation session. And one last point that I would like to highlight in terms of how to have the successful mediation, which is the usage of information of exchange in the course of mediation in relation to other proceedings. It is quite important for the parties to be forthcoming, to have the successful mediation, to ensure such, to ensure that the parties will be forthcoming in the mediation and share the information. It is important to set the rule that information exchange in the mediation will not be used in any other proceedings. But at the same time, there's a challenge on the side of state, because state may wish to maintain the confidentiality. At the same time, state has to be accountable to their public. And of course, the investors needs to be accountable to their stakeholders, but the accountability of the state is much broader because of the political reasons. So there could be a challenge to strike the balance between confidentiality and transparency, and that could affect the rule to be placed in terms of the limitation use of information in other proceedings or in other occasions. But these are some of the complicated element of the mediation involving state and dispute settlement. But as I set out at the outset, there are a huge benefit associated with the investor-state mediation, and I hope to see more investor-state mediation to settle the dispute most efficiently and effectively. Thank you.
Thank you, Yoshimi. Andres, over to you.
Thank you. Thank you, Jerry. I will answer the questions then in turn. So what are the aspects of the ICSID mediation rules that are particularly useful for promoting a successful mediation? I would say that the first obvious point to me, but still a very important one nonetheless, is that the mediation rules constitute a complete set of rules that regulate the mediation process in its entirety, avoiding lacunas or gaps, and therefore facilitating the agreement of the parties to mediate, but also providing a very useful guidance to the parties and the mediator of the different steps and procedures and content of those procedures to be followed for a successful mediation. One example for me is the Rule 20 with the regulation of the first session and the mediation protocol. Second is that the rules contain the basic principles of the two main features for a mediation process to be successful, which is first the consensual basis of the process to enter, conduct, or withdraw from mediation, and also flexibility. And these fundamental aspects, you find them in different provisions of the ICSID mediation rules. Just to give two examples, the consensual nature of the mediation, for example, and a rule that I consider important, is not that only you have mediation by a prior or subsequent agreement of the parties, also can be a mediation or mediation through an offer to mediate. I think it's very interesting that a party can try to seek the agreement of the other party by presenting through ICSID an offer to mediate. The other point that I think is important in terms of the consensual nature is the possibility of the parties to withdraw at any time. I think that liberty of the parties make them probably feel more comfortable to participate in the process. Then, as I said, flexibility. I think an important aspect on the rules in terms of flexibility is that even though the ICSID mediation is available to a state or RAIO, on the other side does not require a nexus to ICSID membership, nor does impose any specific nationality requirements. And as I said, even though the Regional Economic Integration Organization has to be a party or a state, do not prescribe who the other party might be. Could be a national of other state or could be a local entity. Then, in my view, you have a number of interesting rules that are key for a successful mediation. My view, Rule 18 will contain the minimum duty of cooperation of the parties in good faith and in expeditious manner, confidentiality, and the use of information in other proceedings, which are Rule 10 and 11 respectively, which is key for successful mediation in general. The other thing is that the mediation rules can be used at any time during the lifespan of the investment, which make them, again, very flexible. But one aspect that I wanted to highlight that, in my view, makes the ICSID rules particularly useful for promoting a successful mediation is precisely the institutional nature of the ICSID mediation rules. Or say differently, the fact that are administered by ICSID, which it means that is administered by an institution that provides or will provide support for the mediation in a number of critical aspects, which for me, I think is especially important when it comes to mediation. I cannot go through all the aspects in which the support is important, but just to mention a few: assistance with the appointment of the mediator in Rule 13.3 and 13.4, information and guidance on the investment mediation with a separate team from arbitration, a specially dedicated team in ICSID, which I think is also very important. And something that has a significant practical relevance, which is the certification that the mediation took place by the institution, which will allow compliance with the requirements of the Singapore Convention, or also that the precondition of an amicable negotiation took place. Now, what issues to be considered? The second question was decided whether to pursue mediation. The background paper of ICSID, which is a very useful instrument, contain a list of these factors. These factors are very similar to the guidance contained in UNCITRAL, so I won't repeat them, but I would like to highlight three of them. One is the willingness of the parties to enter in a negotiation that will facilitate dialogue through a third party, but still they controlling the process and the outcome of the process. Second was mentioned by Yoshimi already, the desire to continue the relationship of the parties. Investment arbitration in particular can be very adversarial and can destroy value for the state and the investor. Of course, cost and time considerations can be very relevant. But I would say a very important factor for me is obviously the nature of the dispute. Some disputes are more easy to be settled than others due to investment dispute, to social political implications. And something that is especially, I would say, relevant is that mediation can allow the parties to avoid the limitation of the reliefs available under treaties, in particular limited to pecuniary relief. So it gives much more flexibility to find a solution that the narrow scope that usually an arbitration case have will not give. To finalize, the rules are very recent, are from July 2022. There is no cases. I understand from what you share with me, there are not cases yet in which the rules have been used, but it's very important to mention that there is a number of treaties, and it's a very interesting document, an overview made by ICSID as well, that increasingly contain a requirement for mediation, not always voluntary, but in a number of cases also mandatory. So I think we will see this rule to be used much more in the future. Thank you very much.
Thank you, Andres and Yoshimi, for your thoughtful insights on mediation. I just wanted to point out one thing that wasn't discussed. If the parties settle in the context of an ICSID convention arbitration, they can also ask the tribunal to embody the settlement in the award. So that's in addition to the Singapore Convention. And the other thing I wanted to, Andres talked about the ICSID background paper on investment mediation, which is excellent. And we also have some great resources on the website. So there's a whole page dedicated to mediation, so you can see trainings and videos if that's of interest. Okay. So we'll move on to annulment. Okay. So one of the benefits of the ICSID system is that it is self-contained. This means that there is no domestic court review of decisions or awards. Oh, thank you. Oh. Thanks, Lars. Okay. So now I have the right slide on. So annulment is one of the few exceptional post-award remedies. Awards are not subject to appeal and can only be reviewed on 5 limited grounds that are set out here on the slide. Yesterday, ICSID released an updated background paper on annulment, which I encourage you all to read. ICSID's research shows that although annulment applications have increased with the number of ICSID cases over the years, the number of annulment remains low, about 5% of all awards. Interestingly, since 2016, the number of discontinued applications for annulment has increased substantially. Discontinuance of an annulment proceeding occurs in approximately 25% of all annulment proceedings. With respect to the composition of the ad hoc committees, while the number of women appointed was historically low, this number has also increased significantly. To date, there have been 126 women appointed to ad hoc committees. This also reflects the fact that a number of women have increasingly been appointed to the panel of arbitrators by states. So here we'll have Andres and Pierre-Olivier talking about annulment. Andres will look at whether there has been a jurisprudence constante emerging over the last 2 decades of decisions. And then Pierre-Olivier will analyze annulment trends and discuss why there has been an increase in the number of discontinuances for annulment proceedings. So over to you, Andres.
Again, Jerry, this is one of my favorite topics, annulment. So the first thing that I wanted to say before going into more concrete issues of the jurisprudence is that, as we all know, although decisions on annulment do not have formal or mandatory precedential status, as a practice, committees, ad hoc committees consistently consider formal decision as authorities, and especially when those formal decisions have reached a wide agreement of certain interpretative issues. In addition, the parties rely heavily during the arguments of their positions and find support also in previous ad hoc committees' decision. Of course, making the point where those decisions are or correspond to a firm trend or a clear trend by ad hoc committees. So overall, as is the case with ICSID arbitral proceeding, but I say that even more in the case of annulment, past decisions have adopted the weight of a quasi precedents, considering, as I said, the importance that the parties give them in pleading the cases and ad hoc committees giving in reasoning or motivating their decisions. Over time, the predominant criteria adopted by ICSID committees have evolved. Some commentators have spoken about the 4 generations of decisions. I'm not so sure that that's really reflect the reality of the trends in jurisprudence in ICSID annulment decision. My experience, having sat in a number of them, if that there is clear trends, and I would say that after 20 years, you can speak in certain areas as clearly jurisprudence constant, and in others, there is still areas where there are certain trends that divide or go in one direction and also in other direction with respect to certain issues. So what I would like to do next is to focus first in the areas where I think there is a significant common ground, and then refer in some of the grounds, because I don't have time to go over all of them, and obviously people can consult the background paper for a detailed analysis of this, where there is some divergent views in the case law or in the jurisprudence. So first, I think where there is really a significant area of common grounds is in the general principles that apply to the annulment proceedings. And committees have largely agreed. If you go to the background paper, there is many pages of this, of quote, of cases that go in a similar directions. And that probably explain, in my view, the limited number of cases, because basically the committees have largely agreed in one, that the ground listed in Article 52.1 are only the grounds on which an award may be annulled. Second, that annulment is an exceptional and narrowly circumscribed remedy, and the role of an ad hoc committee is limited. 3, that ad hoc committees are not courts of appeal. Annulment is not a remedy against an incorrect decision, and therefore annulment ad hoc committees cannot substitute the tribunal's determination on the merits. Ad hoc committees should exercise their discretion not to defeat the object and purpose of the remedy or erode the binding force and finality of awards. Article 52 should be interpreted in accordance with its object and purpose, neither narrowly nor broadly, and the ad hoc committee's authority to annul is circumscribed by Article 52, grounds specifying the application for annulment. So, taking all these principles in consideration can explain why the summary of all of this is that annulment is an exceptional ground and limited ground for annulling the ICSID awards. Having said that, if we look at the grounds, especially the grounds that's been invoked in more of the cases, we will see that there are some common grounds, but also some divergent approaches. Let's start with the manifest excess of power. In the manifest excess of power, I think there is already common ground what manifest means, which is patent, clear, that so there is no much discussion in annulment committees about the meaning of manifest. But there is some discussion about certain areas where an excess of power may exist. One of them is when exists excess of power with respect to the application of the governing law of the case. Has been discussion about when an error of law, even egregious or not, can constitute a manifest excess of power. And there are two trends there considering the application of different annulment committees. The other ground, which is the serious departure from a fundamental rule of procedure, I would say that there is a jurisprudence constant or a clear trend with respect to what a fundamental rule of procedure means, which is referred to fundamental issues of due process, equal treatment of the parties, the right to be heard, treatment of evidence and burden of proof, etc. But there are some differences in when when the breach of a fundamental rule of procedure is serious. And in that sense, annulment committees have considered that the seriousness requires a material impact on the outcome, where others consider that is enough, that would have a potential impact on the outcome. The second main use ground for annulment is the failure to state reasons. In the failure to state reasons, the committees agree in general that the reason should be intelligible or understandable, non-contradictory, and stated in respect of every question. We all know this, very frequently used formula of the case that said that the reader must be capable of understanding how the tribunal got or went from point A to B. But there are different views on whether tribunals are required to state reasons that are adequate or sufficient, relevant, or necessary. And there you can see that there are two trends, and probably these two trends are explained because the tribunals are really in a very fine line between what could be considered an appeal and what can be considered properly an annulment. An appeal where the tribunal disagrees with the motivation, or an annulment where there is a lack of motivation. So even with the group of ad hoc committees that agree that insufficient and inadequate reasons could result in annulment, there are different positions as to the extent of insufficiency and inadequacy required to justify annulment on this basis. Also, while there is consensus on the fact that failure to state reason in respect of every question put before the tribunal amounts to failure to state reason under Article 52(1)(e), there are different views on the meaning of what is a question. For some committees, questions akin to a claim, while for others, it concerns arguments or issues that have certain relevance to the dispute at issue. So, coming back to the original question and looking at the trend, it's possible to see that after 20 years, there are clear common grounds that are, I would say, pacific in terms of what is the position and interpretation of the different aspects of the annulment proceedings, and another where these different trends are perceived. My expectation is that as long as the time evolves and more cases are decided, we will see, as it happened in the 20 years, this more convergence in the decision and more, and that the differences will be increasingly limited in terms of what the annulment committees consider in the interpretation of the grounds. And I think with that I can stop.
Thank you so much, Andres, for your overview. And now to Pierre-Olivier.
Thanks, Jerry. So you're asking me to kind of look in my crystal ball and try to divine why there has been an increase in the number of discontinuances. I'd be interested in ICSID's theory about it, but I'll try and present my own. No, you can go ahead.
I was also going to say, if you would like, you can comment on some of the trends.
I'll do that after. With respect to stay of enforcement and costs and those related issues, and try to see if there's trends. So why do you have discontinuances? Because maybe when you are subject to an adverse ICSID cost, an ICSID award, whether on costs because you're the investor who lost and maybe there's a few million in costs against you, or your estate, and you've lost on damages and potentially there's much more against you, an ICSID award is dangerously efficient in its enforcement. For example, if you go to France, you will get the transformation of the ICSID award within 2 to 4 weeks, and you will have an absolutely enforceable award which cannot be contested, except if it's intra-EU, but that's a whole other discussion. So within a few weeks of losing the ICSID award, you are at risk of having your bank accounts attached, airplanes if it's a state-owned company, vessels, whatever. Or if you're an investor and you know, and there's no deadline. There's nothing in the rules or in the convention which says, you know, it's kind of suspended. The award is in force, so you're at serious risk. So the first thing you may want to do, independently of what you're actually going to do 6 months later, is file for annulment, request a stay of enforcement, and kind of defer your problems, which are really cash flow management. So you do that, and then you get the automatic stay of enforcement. You're not at risk anymore, and until the ad hoc committee is named, and within 30 days they're going to have to decide on whether you continue the stay of enforcement. You buy a little bit of time. Then when you get the first call for funds, it depends on whether the client wants to pay it or not. 200,000 US, 300,000 US. That's usually the approximate amount that you're going to have to deal with. But registering an annulment is 25,000. So it's if you're dealing with, you know, adverse costs of a few million or an adverse award of a much more, maybe you just want to protect yourself and start. Why do people discontinue after that? I haven't looked enough in terms of who discontinues. Is it states? Is it investors? There's a number of cases with respect to stay of enforcement concerning investors where the information is not available. So I think that to a certain extent, you will have people who will start them, just start them and deal with the situation and push back problems. They're unhappy, they want to contest, and then they don't want to pay $300,000 to start or continue the process. So I think that may be one of the reasons, maybe, and because they also know very well that the chances of success are low. For case in respect of...
Or low for annulment.
Sorry?
For having the award annulled.
Yes, they're very low, the chances of success. The numbers are, for all annulment cases started, there's a 10% chance, or only in 10% of the cases, you will have full or partial annulment. For the cases, well, based on the numbers that I saw in the report, and no?
Overall, it was 5%.
5%?
And then in the last, I think it was since 2011, it was around 2 points, about 3%.
So it's very, very, very low, which is why maybe you don't want, if you've got 3% chance of succeeding, maybe you don't want to spend $300,000 or $600,000 to fail. So maybe people decide. So I don't know. That's my hypothesis why you have some discontinuances. I don't know if you have other theories, but you probably do. So in terms of trends, I thought that it was interesting to look at the numbers that you had on stay of enforcement and how that works. There's been once you start an annulment proceeding, I mean the first thing that people will want to do if they're subject to a cost award is often ask for suspension of the enforcement. I'm trying to find the... So there's 5 issues: stay of enforcement and whether the continuance is granted with or without conditions, cost awards in annulment proceedings, who gets them and when. So those, actually not 5, the other ones are things that Andres touched upon. So I'll look at those 2 issues. So I think that the trend regarding whether a stay of enforcement is continued with or without conditions, such as, requiring a written undertaking or posting of security, is simply one. The trend is that the decision will be based on the specific fact of the case. If you look, there's been about 120 decisions, 22 you don't have information. In about 30 cases, the request to continue the stay was rejected. In about 24, 25 cases, the stay was continued without conditions. And in some 30, 35 cases, the stay was continued with either posting security, about 20 cases, or written undertaking, 15 or so cases. So you almost have a more or less 1/3 split of what's going to happen. Your request to continue is rejected, accepted without conditions, or with conditions. So I assume that if it's so evenly split, it has to be very fact-specific. The other question that you want to ask yourself when you start an annulment proceeding is, am I going to get my costs back, and how does it work? And it's really divided in 2 types of costs. The ad hoc committee costs, the 300,000 that's advanced, and maybe with a second call of funds to pay the ad hoc committee, those costs. And then there's actually the question of the legal costs and disbursements. Regarding the costs advanced to the committee, the costs were divided they were divided equally in about 20% of the cases, which means that the applicant received half of the advance back. The full costs were borne by the applicant when it failed the annulment, basically about 70% of the cases. And the respondent in the annulment had to pay the applicant's full costs in about half a dozen very few cases where the annulment application was successful. So it more or less follows the event for the ad hoc committee costs. The trend is that ad hoc committees usually rule that each party will bear their own legal costs. They don't usually apportion. That's for about 70% of the cases. In about 20, 25% or 30% of them, the committee held that the applicant actually should pay the full legal costs of the respondent for the annulment, so I assume that the annulment grounds were not very good. And it's extremely rare for somebody who applies for annulment to get their full costs. And there's 2 cases, as far as I've seen. One does not involve very much costs. ATA versus Jordan, there was some sort of agreement and they were supposed to pay the applicant's costs. But the outlier, which is very interesting, is ICSID versus Spain, where Spain sought annulment because there was a conflict of interest between the arbitrator and the damages expert, because the arbitrator was found to have used the same damages firm as counsel. The award was annulled and Spain was granted all of its costs, 3.5 million US, which is really an outlier in terms of costs for annulment, but I thought that was interesting. So those are kind of the costs, the trends that I wanted to mention.
Thank you so much for that. I think Lars wanted to.
Can I just add one point? I'm not sure whether we can call it a trend, but since it's very recent, I think it's very interesting. There is a case and a decision that has come out on 2nd of February 2024 in the case NUKL versus Tanzania, in which the annulment committee summarily dismissed some of the annulment grounds. So you probably know the summary dismissal is one of the great inventions of ICSID that has been now taken over by all the commercial arbitration institutions.
It's my favorite one.
So if there are grounds that manifestly lack legal merit, an arbitral tribunal or an annulment committee can go ahead and summarily dismiss things. And in annulment proceedings, this is very difficult because when you file your application, you don't have to substantiate much, so there's not much to go against. But this annulment committee looked at, I think it was different 19 reasons why the award should be annulled, and went at least half of them and said, like, from the face of the award, it's just obvious that this annulment ground does not make sense. So why not dismiss it already now and focus on the grounds that, I cannot summarily dismiss. And I think I hope this will turn into a trend, because that might make annulment proceedings quicker and more efficient.
Yeah. So that was the first case. Yeah, thank you so much for that. I think we had a great overview from Andres about where the jurisprudence is and where there are some issues that still need to be worked out. And thank you so much to Pierre-Olivier for the trends, and for Lars for talking about the, I guess no longer, is it 41.5 still?
No, it's the new 41, I think.
Yeah, perfect. And then we also talked about the updated background paper on annulment, so that's now out. So I recommend that you read that. Okay, so we'll go on to our last topic, which is enforcement. So under the convention, an ICSID award is final and binding on all parties to the proceeding. Each party must comply with it pursuant to its terms. And in fact, a majority of awards are complied with voluntarily, so that's important to note. If a party fails to comply with the award, the other party can have the pecuniary obligations recognized and enforced in the courts of any of the 158 ICSID member states, as though it were a final judgment of that state's courts. This simplified enforcement procedure is another special feature of the ICSID system. ICSID is currently conducting a study on how the provisions on recognition, enforcement, and execution of the convention function in practice. Meg mentioned that earlier this morning. So we hope that's going to be published a little later this year. I think Meg said in a few months. And we're going to have Yoshimi and Lars conclude on this topic. Yoshimi is going to cover the benefits to having an ICSID award enforced as a final judgment of the state, as opposed to an award being enforced under the New York Convention, and also talk about the framework in Japan. And Lars will discuss the effect of the recognition and enforcement of an ICSID award and the risks for a state if it does not comply with an ICSID award. So over to Yoshimi.
Thank you. I think Pierre-Olivier has already set the ground for the efficiency of enforcement in France. What did you say? Within 3 weeks?
2 to 4, 3.
2 to
3 is the perfect average.
That sounds fantastic. So if you represent, investor, of course, there are a number of elements you will take into account in deciding whether to use the ICSID framework or UNCITRAL framework, but definitely this efficiency of enforcement is one of the biggest reasons why there are so many investors are bringing claim under ICSID convention. Why? So you already know it is much more efficient, much more certainty, and less surprise. So both ICSID convention and New York Convention, each contract provides that each contracting state shall recognize an award. But as you know, New York Convention has another provision, which is Article 5, and which provides the list of grounds based on which the state may refuse to enforce an award. But there is no comparable provision within ICSID convention. By that, it means that state cannot rely on whatever provision within the ICSID convention to refuse to resist enforcement of, resist the recognition of award and enforcement of pecuniary obligations. This is also provides an efficient mechanism because in the New York Convention, investor or state has potentially two jurisdictions. The first jurisdiction is the jurisdiction of the seat of arbitration, and the second jurisdiction is the jurisdiction of enforcement. So New York Convention are in many jurisdictions introduced into the Arbitration Act, and these Arbitration Act provides the ground to refuse to enforce an award. And also, UNCITRAL model law provides comparable grounds for setting aside an award. So, in other words, a party to investment treaty arbitration has fight twice on the same, almost the same grounds. But as you might know, those grounds under Arbitration Act, which is those grounds listed in New York Convention, and those New York Convention's grounds are often incorporated in Arbitration Act, but those grounds are interpreted differently from jurisdiction to jurisdiction. So you have to fight on over the same language, but perhaps based over the different jurisprudence in different jurisdiction. And those complications are completely removed in ICSID Convention. That means, as the audience has already heard, how, annulment decisions had been converged. So you have to first deal with this, annulment proceedings under the ICSID Convention. And if you survive, if the awards survive, that's the end of the story. There's no more chance for losing party in the ICSID award to resist enforcement of award. That's the significant efficiency of enforcement of ICSID award. Recently, I think in 2023, with my due respect to German colleagues, Higher Regional Court of Berlin dismissed the Indian government allegation that awards should be set aside on the public policy ground. That this is the case between Deutsche Telekom versus India, and this case is UNCITRAL award. So investor has to go through New York Convention mechanism. Under New York Convention mechanism, one of the notorious or famous ground is public policy ground. So Indian government tried to set aside to resist an enforcement award on both procedural public policy and substantive public policy, and Indian court India's allegation were dismissed. So eventually, the conclusion of the New York Convention and ICSID Convention could be the same, but the time and cost involved to get to that conclusion is enormously different. So this kind of ground couldn't have been, of course, brought up by losing party in the context of ICSID award. So that's the benefit of the enforcement mechanism. Another benefit associating with the enforcement mechanism of the ICSID Convention is state unique immunity defense. In many jurisdictions, Article 53 and 53 to 55 of ICSID Convention are considered to remove state jurisdictional immunity defense, whereas New York Convention, there is no equivalent provision, and interpretation of New York Convention is left to each state. So in terms of jurisdictional immunity defense, ICSID does provide clear guidance to the member state. Now I want to move to the mechanism, the framework of enforcing ICSID award in Japan. Unlike US or UK and some other jurisdiction, Japan doesn't have any special legal framework to implement the enforcement of ICSID award. Unfortunately, hope we will see something the special law to enforce the ICSID award sometime very soon. Then what should a prevailing investor do? As to the pecuniary obligation, it says each contracting state shall enforce the pecuniary obligations imposed by the award, within its territories as if it were a final judgment of the court in that state. But that doesn't mean that the pecuniary the award which provides the pecuniary obligations can be automatically treated as a judgment of Japan, for example, the Japanese court. The award has to be entered into the Japanese court. So what would be the mechanism to do so? That is, in my understanding, Arbitration Act will be used to make the award entered in Japanese court. So a prevailing party of ICSID Convention may apply to the apply for the enforcement, recognition, and enforcement of ICSID award under Arbitration Act of Japan. And as you know, Arbitration Act is consistent with UNCITRAL model law and New York Convention. By that it means it lists a number of grounds to resist an enforcement and award. How does it work? Well, it has been untested, but the state, Japan, as a member state, as a contracting state of ICSID Convention, is obligated to recognize and enforce pecuniary obligations. Therefore, the Japanese court cannot refuse to enforce an award on the ground listed in Arbitration Act. So although the Arbitration Act will be the framework to enforce the ICSID Convention, the Japanese court is obligated to comply with the treaty, which overrides the provisions of Arbitration Act to the extent the pecuniary ICSID arbitration award or pecuniary obligation is concerned. So I should conclude my remarks here?
Sure.
Thank you.
So over to Lars.
Right. I'm going to tackle the question, what effects does the recognition and enforcement of an ICSID award have? And for the risk of sounding a bit academic, I think that the one very interesting effect is that if you look at the ICSID system, it is decoupled from national jurisdiction. So you have that. That's why you have the annulment proceeding. That's decoupling it. You have Article 26, Article 27, Article 44, competence. All of these provisions decouple ICSID proceedings. There's no seat of the arbitration.
Self-contained.
It's a self-contained system. So the effect I see here, once you get to recognition and enforcement, that's when you have to step down from your decoupled self-contained cloud and you arrive back in reality and you actually come back into a national court jurisdiction. So that's for me the first effect. And then this is basically governed to a large degree by the ICSID Convention, and Ohara-sensei has already said that. We have Articles 53 through 55. So Article 54 is interesting because, yes, you have to, a contracting state to the ICSID Convention has to enforce the pecuniary obligations imposed by the award as if it were a final judgment of a court in that state. How do you do that? The member states to the ICSID Convention are obligated to provide the competent court in their jurisdiction that you would address with such issue to ICSID. And if you look on the ICSID homepage, you can actually find a little drop-down menu. And if you're so interested, you can check for each country, which court do I have to go to? Mm-hmm. And ICSID has to always make sure the countries update that information. I can tell for Germany, I think once I looked and I felt it wasn't quite updated. So be careful, ask a lawyer who knows. But that's basically how you go about it. And then the interesting thing is the ICSID award needs to be recognized and enforced. And with that, you receive something very often that is, in a sense, a stamp by the court or something that a court issues, and then you take this to the bailiff and you proceed to the execution. And this is in Article 54, subparagraph 3, where it says execution of the award shall be governed by the laws concerning the execution of judgments enforced in the state in whose territories such execution is sought. So that's when you're completely back in the national realm, and the court bailiff has to go and enforce by whatever means that is provided for in such jurisdiction. Now, one thing we've talked about immunity from jurisdiction. Interestingly, Article 55, this is where the ICSID Convention draws a line and says, while we basically take away your argument you have immunity from jurisdiction, you have submitted to the ICSID Convention, what the ICSID Convention doesn't touch is the immunity from execution. And so in each member state in which you take this very simple proceeding and you take the ICSID award and you convert it into something, still you have to see what then can I enforce into. And most, I would say, modern, sophisticated states have a kind of a separation, and that says you can enforce into assets that are used by a state for commercial purposes, but you cannot go and enforce into assets that are used by the state for sovereign purposes. And just to give you the typical example, I think you mentioned it already, if you have a national airline, you use that for commercial purposes normally, and so you can wait at the airport and attach those airplanes. And that's there were states that had considered privatizing their airlines, but they also knew they had a lot of ICSID award creditors, and so they scrapped those plans because they were afraid that people will immediately attach the airplanes. What you cannot do is walk to the next embassy and says, well, give me your Mercedes-Benz S-Class and all your bank accounts. These are sovereign assets, so that you can't do. And so this is something you really have to look into. Very interestingly, the Republic of China has just amended its laws in that respect. And China used to have a full immunity from execution. So they didn't care whether it was state assets, or sovereign assets, or commercial assets. And it has just, as I understand, made this a bit more fluent and has introduced the possibility to enforce into commercial assets. So I'm not the expert on that, but this is what I recently read. So as we see, you have a great effect, but there's a lot of little details you still need to think about when you really want to enforce or execute. That's sometimes we should make this distinction. Now, to my last point, what are the risks for a state if the state doesn't comply with the award? And one of the first things that I learned when I started looking into ICSID arbitration, how it works, some 20 years ago, was the World Bank effect. I'm not sure whether ICSID and the World Bank really subscribe to that, but that's quite well known. One argument is if a state doesn't comply with its obligations under the ICSID conventions, of course, ICSID and the World Bank, to which ICSID belongs, are going to take note. And so the next time a state applies for funding by the IMF or something, that might get a little bit more difficult. That is at least what you read in the legal literature. Whether this really works in practice, I don't think anybody at the World Bank will give you an answer. But I think it's good to have this out there. Another effect is, of course, and that's governed by Article 27 of the ICSID Convention, there's a revival of the possibility to provide diplomatic protection or bring international claims. So if you don't comply with your obligations under the award, you might be faced by a claim of the host state, of the investor, saying like, hey, you should have paid my investor. But very interesting, there are also almost case examples of what happens. And the real case study is Argentina, I would say, which after its economic crisis faced a lot of proceedings, was in a lot of trouble, had a lot of ICSID award rendered against it, but really tried to make sure not to comply with these awards. Also, one could say didn't really comply with Article 54 of the ICSID Convention because it required investors to go through almost national court proceedings for the enforcement. So a lot of investors said, no, I'm not going to do that. That's not provided for under the ICSID Convention. And so there's a lot of back and forth. And what happened in that case is that indeed, mainly under the leadership of the United States, back then President Obama, states started exercising pressure on Argentina. And definitely, at least the United States took the positions that they would not support Argentina with further IMF loans. And that eventually led Argentina to settle 5 of the ICSID cases, and actually that pressure helped Argentina to get rid of some of these open ICSID awards, partially by again issuing sovereign bonds. So you can see there is some pressure mechanism. I think with that said, it's also important to note that the majority of ICSID awards are complied with voluntarily. So these are theoretical scenarios that are good to know. But actually in practice, normally, you should be able to expect that states want to comply with their obligations. Similarly, I think where it gets a bit more difficult is when investors lose a case and have to pay the costs. They sometimes tend to disappear a little bit, so that's a bit more complicated. I'm very glad to see that I run out of time, because otherwise I would have to address the intra-EU issue, whether the EU would enforce ICSID awards, but I have to say I'm out of time. Very sorry.
Well, thank you so much, Lars. So we are out of time for this session, so I would like to just express my sincere thanks to our very knowledgeable panelists, Andres, who's online, Pierre-Olivier, Lars, Yoshimi. Thank you so much. And I'd also like to thank the Ministry of Justice for their kind invitation and having us. Thank you. And to the audience, of course, for listening to us for the last 2 hours.
And to our moderators, thank you very much, Jerry, as well.
Indeed.
Thank you, Ms. Fisher, and thanks to all distinguished speakers for the excellent presentations. Please give a big round of applause to Ms. Fisher and all distinguished speakers of panel 2. Because of time constraints, I would like to pass the floor to the Director Imai for his closing remarks. Mr. Yasuaki Imai is the director of the international team of the Litigation Bureau of the Ministry of Justice, and he has been leading the team since April 2023. Mr. Imai, you have the floor.
Distinguished participants here and joining online, I am Imai Yasuaki, Director of the International Judicial Proceedings Support Office, Litigation Bureau, Ministry of Justice of Japan. I have the pleasure to make a few concluding remarks at the end of this session. It's a true honor for us to be able to work with ICSID and to co-organize the ICSID session of the Tokyo Forum for the 3rd time. I'd like to extend my gratitude to everyone involved in this session. In particular, I'd like to express my sincere gratitude to Ms. Meg Kinnear, Secretary General of ICSID, for co-organizing and moderating this session. I strongly believe that Ms. Kinnear's wonderful moderation made this session so successful. Ms. Kinnear has moderated ICSID session since the first Tokyo Forum, and without her, we would not have been able to make every ICSID session successful. I'd also like to strongly thank Ms. Geraldine Fisher, Senior Legal Counsel of ICSID, for her tremendous contribution to this session. I would like to emphasize that Ms. Fisher has contributed to making the Tokyo Forum fruitful since 2021. This session would not have been closed very successfully without Ms. Fisher's great contribution, as well as Ms. Kinya's contribution. Moreover, please let me express my sincere appreciation to all the distinguished speakers in the panel one, Ms. Abby Cohen-Smutny, Mr. Michael Nolan, Professor Chiara Giorgetti, and Ms. Anna Juban-Bure. In the panel two, Mr. Andres Hanna-Lunetsky, Mr. Pierre-Olivier Savoy, Dr. Russ Market, and Ms. Ohara Yoshimi. It is a great honor for us to invite such world-famous speakers who have abundant experience and expertise based on their various backgrounds. The diversity of speakers has deepened the discussion. Without this participation, we would not have had such fruitful session. 4 important topics were addressed in this ICSID session. First, having Ms. Anna Juban-Bure as one of the panelists, we had a discussion on the UNCITRAL Code of Conduct for Arbitrators in International Investment Dispute Resolution, which was adopted at the Commission of UNCITRAL in July last year through the collaborative work of the UNCITRAL Secretariat and the ICSID Secretariat. I believe this topic was really timely and perfect for the forum co-organized by ICSID, UNCITRAL, and the Ministry of Justice. Secondly, we had a discussion on practice under the new ICSID rules. At the ICSID session of the first Tokyo Forum held in 2021, a discussion was held on the project of amendments of the ICSID rules, which was in full progress at that time. At the ICSID session of the second Tokyo Forum held in 2022, there was a discussion on particularly important provisions of the new ICSID rules, which have just come into effect in July that year. And this year, we discussed practice under the new ICSID rules with cases proceedings under those rules. Discussions on the third topic, annulment in the ICSID system, and the fourth topic, enforcement of ICSID awards, were also fruitful discussions on important systems that characterize ICSID arbitrations, thanks to the distinguished panelists with diverse experience and expertise. Japan is one of the first contracting states to the ICSID Convention. The bond between ICSID and Japan is long and strong. I am convinced that the strong tie between ICSID and the Ministry of Justice of Japan enable us to successfully co-organize today's event. I'd like to assure all of you that the Ministry of Justice of Japan is determined to continue its strong support for ICSID. Finally, once again, I would like to express my sincere appreciation to all participants around the world and to everyone involved in this session. Thank you very much.
Thank you, Mr. Imai. And on behalf of the co-organizers, I send my heartfelt thanks to all distinguished panelists, speakers, and contributors to Session 1. And thanks to all the attendees for their participation. With this, we conclude Session 1. We will resume forum at 4 p.m. Japan Standard Time, which is 7 a.m. Greenwich Mean Time, for starting with Session 2. Thank you once again, and see you later.